But the Honorable Single Judge didn't touch this act and passed any another types of order which without issuing notice for filing counter, and the matter has not been properly adjudicated. Hence, this writ appeal has been filed for consideration.
The question, the matter involves, the writ application involves disputed question of facts. You can file a suit.
In a way, you are claiming adverse position.
No adverse, not adverse person.
So you have to establish your
Act
right.
says that. Act says that
You have to establish your right there, not here.
it has been established, my lord.
Learned Single Judge has
The church authority already made certificate that this church is established since 1947.
Para 5, clearly the facts have been stated as physically verified, and the facts have been settled by collector and district magistrate.
My lord, this
In
is
case you are aggrieved, you can.
the law doesn't provide any suit for any suit or any proceeding except this act. My lord, this is the act. Your lordship may see the act. Then no, after 1991, no suit shall lie. This is the law, my lord. If your lordship will,
Let us see.
yes, madam. Your lordship may issue notice and
Let us see the provision first.
yes. No, such nahi badai thi. Achi na.
So who is constructing temple?
My lord,
Who is constructing temple?
this is a church, madam.
Who?
No, the Hindu religion. In Hindu,
Private persons.
yes, person, but it has been persuaded by the railway authority, opposite parties, number 3 and 4.
Sir, who, according to you, who is constructing the temple? You have a grievance
Yes,
that some persons are constructing temple
yes, madam.
over the
So
land.
railway authorities, madam.
Railway authorities are constructing temple.
Since the land is in your possession, it has not been disturbed.
In your possession. Who
Yes.
are you?
In church,
You are the church. File a suit.
no, minor suit is not applicable, minor. Your lordship may see the act. After 1991, no suit will lie or no proceeding will lie.
Your submission prima facie appears to be absurd, but still we are compelled to see the provision.
Yes.
Which provision?
Section 3 bar of conversion of places of worship. No person shall convert any place of worship of any religious denomination or any section thereof into places of worship of a different section of the same religious denomination or a different religious denomination or any section thereof. Declaration as to the religious character of certain places of worship and bar of jurisdiction of courts, etc. It is hereby declared that the religious character of the place of worship existing on the 15th day of August 1947 shall continue to be the same as it existed on that day. If on commencement of this act, any suit, appeal, or other proceeding with respect to the conversion of the religious character of any
Which
place.
provision you are reading?
Minor?
Which provision you are reading? Three.
Section 4, minor.
Section 4.
Yes. If on commencement of this act, any suit, appeal, or other proceeding with respect to the conversion of the religious character of any place of worship existing on the 15th day of August 1947 is pending before any court, tribunal, or other authority, the same shall abate. The same shall abate, and no suit, appeal, or other proceeding with respect to any such matter shall lie on or after such commencement of
Let
this.
us read first. Please stop. We are reading.
Yes. Section 4, subsection 2.
What is HSL?
HSL Hindustan Steel Limited. It was acquired for that purpose, but they have surrendered this, and it has been handed over to railway. But the railway has not taken the possession. That is the law. That if any person has not been taken, that should be restored.
You are in forcible possession of that land and you want to convert it. So first of all, you establish your title over that land, then you may.
I have established my. Well, in record of right, my name is recorded as forcible occupier since 1965.
What is it saying? Since 1965 on.
Minor.
You are there since 1965.
This church was established in the year 1945 manner. This is the certificate issued by the church authority. Certificate is there. How they?
So there is no dispute about that.
No, man.
How do you say?
Dispute.
You have
No,
you have not made any document part of this record.
Document.
Neither before this learned signatures nor before this court.
Document, minor. Only this document is that I am in possession since 1945, and according to this places of worship special provision act, I am
Without
entitled.
any evidence, we will hold that.
Minor evidence.
Without any evidence, we will hold that. You want us to hold that.
Evidence is minor settlement authorities.
Evidence is with you. You keep it.
No, evidence means the settlement authorities order.
That's not before us.
Minor.
That's not made part of this record.
Yes, the settlement authority already observed after spot verification that the church is continuing since 1952.
That you are saying.
Minor.
That you are saying your oral statement.
Oral nahi. Minor, this is the order under annexure. Your Lordship see annexure of the writ petition, copy of the settlement office, appeal number 15 to 19. Your Lordship may see 15 to 19 on the writ petition. This order was passed at the time of verification of spot. The Lordship may see. This is the strong evidence against the opposite
You
party.
prove that.
Minor?
You can prove that before the appropriate court.
There is no. The proof is that the record of right is in my name as a possible occupier. And the settlement authorities have passed order that you are in continuous possession and it is 1 acre 22 decimal is under your possession. It has been written by them. The settlement officer passed order. This is the proof, my lord. Let them deny, my lord. Opposite party should deny that it
We
is,
will not enter into such disputes.
my lord.
We will not. The appellant in the present intra-court appeal has put to challenge an order passed by a learned single judge of this court dated and so passed in WPC number 25690 of 2023, whereby the writ petition filed on behalf of the appellant under Article 226 of the Constitution of India has been dismissed. What is your name?
My name Bharat Kumar Mishra.
No, not you.
Petition name. Jaljan Lakra.
How are you connected with that church?
He is the president, man.
Where have you said?
In the Jaljan Lakra church. Repainting the jail charge. Repainting is as a president.
How are you connected with the church?
He is conducting all the cases and he is the president.
The appellant has asserted that in the writ proceeding that Gosner Ibn Gilgal Lutheran bracketed GEL Church is a branch of Central Council of Churches at Ranchi and is being administered by Northeast Church, namely Chota Nagpur Council and Assam Church Council, established in the year 1845. So stop. He filed the writ application seeking direction to the opposite parties number 1 to 4 not to convert the place of worship, that is the Christian church of the petitioner, by taking forcible steps for construction of a Hindu temple within the premises in contravention of the provision under the Places of Worship bracketed Special Provisions Act 1991. Stop. In response to a query as to how the appellant is connected with the said church, Mr. Misra and counsel appearing on behalf of the appellant has submitted that he had been representing the cause of the church since long. So stop. He has referred to section 3 of the Places of the Act to contain that conversion of the church, which is a place of worship, by worship of Christians cannot be converted into a place of worship of Hindus by constructing a temple. Stop. He has further submitted that the church is existing since 1945, and therefore no suit can be filed by operation of subsection 2 of section 4 of the said act. Oh, stop. Before addressing the submission advanced on behalf of the appellant, we deem it appropriate to refer to paragraph 5 of the impugned order, which has taken into in which the finding of the district magistrate Sundargarh has been taken into account, comma, in respect of the controversy in question, paragraph 5. So stop. After having considered as noted above, learned single judge has hailed in paragraph 6 as under. So stop. Next. We are of the considered view that firstly, the petitioner has not been able to establish his locus standi to maintain the writ application. So stop. Secondly, when single judge has arrived at a conclusion that the petitioner, after having lost in all the fora, had approached this court with the baseless allegation that a temple was being forcibly constructed over the land in question. So stop. The land has been found not belonging to the GEL church, which is in forcible possession over the same. So stop. We do not find any reason to interfere with the decision of learned single judge in an intra-court appeal. This appeal is accordingly dismissed without pause.
Order certified.
That in the affidavit portion of the writ petition, petitioner has described himself to be representing GEL church, and at the same GEL church without disclosing any connection between him and the church. Further, in paragraph 1 of the affidavit, he has stated that he is the petitioner of the case.
Item number 2. My lord, I am seeking one adjournment, my lord, due to my personal difficulties, my lord. I pray for 2 weeks after this matter and can be taken up.
we have already solved the supplementary affidavit, my lord. With respect, my lord, I am difficulty little bit personally preoccupied. So I have already solved, my lord, the supplementary affidavit to the state, so also to the CBI, who is also on board, my lord. So also the
Counsel, prima facie, we are of the view that filing of the writ application is an abuse of the process of court.
your lordship,
And
what I am paying, my lord, because I am in
Misuse
difficulty.
of public interest litigation.
Your lordships,
So you are seeking adjournment, we are granting adjournment, but with an assurance that if we finally reach a conclusion that this is abuse of the process of the court, we shall be imposing exemplary cost.
My lord, we
Whenever
will be
you
bound.
want to- Yes,
My lord, we will be bowed down to your lordships.
yes, you will have to.
But with due respect, my lord, what I am submitting,
We will see later.
let the CBI file an its affidavit.
CBI, we will not allow CBI to file an affidavit
No, he has
unless
already
we are
filed an
satisfied that
affidavit.
CBI has something to do.
My lord, the CBI.
your lordships, I am appearing on behalf of CBI. If your lordship will give me 2 minutes time, only 2 minutes.
Yes,
Your lordships, for a moment, I don't want to go to the locus of the petitioner, but our stand in past has been, your lordships, we have written 2 letters, your lordships. One is a letter dated 30/9/2019 and letter dated 9/12/2019 to the Orissa State Government Chief Secretary to transfer the case to the CBI. Why we have done so, your lordships? Because the Ministry of Shipping has written a letter and unanimously, your lordships, the Paradip Port Trust, the Shipping Ministry and the CBI wants to take up this case. This case, your lordships, involves international ramifications, number one. Number two, your lordships,
under which provision have you requested?
your lordships, there is a general consent with the state government. The crime branch is already investigating the
that?
matter. Yes,
Where
your
is
lordship.
that?
Your lordships, I want to file a counter affidavit stating everything, your lordships, and argue the
Sorry,
matter,
no
lordships.
notice has been issued. Why will you file a counter? I don't
I
know.
want to file a counter. I'm seeking
No,
the
I'm
permission of the
sorry.
court.
No notice has been issued by the Honorable Court.
We will
Your
see.
Your lordship, the advocate general, I am
Why
making a
the
request
state
to the
is-
no, I don't
why-
have to take your permission to file a counter. I'm asking the court with due respect.
I am making a
Mr.
submission to the
Let
Honorable
us
Court.
understand the statutory provision. You are saying there is
Yes.
some
I want-
agreement between you and the state government. Where
No,
is that?
Your
Let us
lordship,
understand. Let us
Your lordship, I
understand
want-
legal provision first.
yes. Your lordships, under section 6 of the Delhi Special Police Establishment Act, there is a general.
Let us
Lordship, may kindly come to Delhi Special Police Establishment Act.
Let us see.
Yes. Section 3, your lordships, may kindly. May I read your
When was
lordship?
the letter written to the state government?
Letter it was written on 30/9/2019, your lordships. First letter.
19.
Yes. After that, your lordships, the second letter, a reminder letter, was written on 9/12/2019, your lordships. To transfer the case for further investigation in FIR number 28 of 2019, your lordships, 2 letters have been written, in fact. One is a reminder, one is a primary letter. The first is,
So is it permissible in law, Mr.?
your lordships,
After closure of evidence, can you compel
evidence
the
was not
government
closed.
to
with due respect,
go
your
for
lordships,
further investigation?
your lordships, in chit fund cases also, the Honorable Supreme Court has directed after the filing of the charge sheet, when the supplementary charge sheet has not been filed, the cases have been transferred to your lordships.
La-
So in this case, there is no closure, your lordships.
Delhi police. You are referring to section 6?
Section 6 and section 3, your lordship. We have a general consent with the state government. The state
Where is
government,
that?
your lordship, may kindly come to section 6. I'll file that. If your lordships will permit me, I can file that consent.
We will see.
Yes, your lordships.
We will see later. Neither you nor he is ready.
Well, let the matter come to.
Your lordships, I am ready with the
We'll,
matter. I want. Now, your lordships, the counsel for Paradip Port is also here. The Paradip Port had filed an affidavit before this honorable court in 2018, stating that CBI needs to take up this case, your lordships.
Just a minute.
Yes.
To paragraph 6, you can seek consent. TS section 6.
Your lordships, we can seek, your lordship may kindly come to section 3 first. Section 3 of the Delhi Special Police Establishment Act. Lordship, may give me
Yes.
2 minutes. I'll just explain. The central government may by notification in official gazette specify the offences or classes of the offences which may be investigated by the CBI.
Yes.
With Orissa government, your lordships, from 1950s, I'll file that we have a general consent. But this case has already been investigated
We will
by.
see. We will see.
Yes. But
Whatever they are saying, they let them bring to the notice of.
your lordship, I filed a counter. I'm filing a counter affidavit. Lordship may consider it.
As
Yes.
requested on behalf of the petitioner, when do you want?
Yes, my lord. 2 weeks adjournment, my lord.
List
Any date, one can
2 weeks. Petitioner is seeking adjournment.
Yes.
Item number 3.
In between, my lord, the CBI let me produce the
Yes,
affidavit that he has already filed before this honorable court. In an earlier WPC, my lord, that I have also mentioned in the money prayer also.
Your lordship may pass any order. Let me bring everything on record, your lordship, so that I can argue. Obliged.
Item 3.
Oblige.
May I please the lords? My lordship, item 3. The appellant seeks to challenge the order passed by the Honorable Single Judge in which he was aggrieved by the order of the sub-collector, who is respondent number 1 in this case. The sub-collector in that case had directed the Tahsildar to mutate a certain piece of land under OLR
Where is
90.
the order of the learned single judge?
Lordship, the order of the learned single judge is Annexure 5, which is in page 39.
Yes.
Lordship, the case was admitted, and after a few hearings, it was the Honorable Single Judge had disposed it off on the ground of an alternate remedy. But prior to that, there were several.
Such type of orders are the domain of letters patent appeal.
Lordship, it is under letters.
You are in letters patent appeal.
My Lordship.
We are in writ appeal. Is it within our jurisdiction to entertain such type of orders against the learned single judge? Are you sitting in appellate as appellate authority?
You had an alternative remedy.
Lordship,
What is the illegality in the order?
Lordship, the illegality was the 19(1)(c) of the Orissa Land Reforms Act is a partition which is on mutual agreement.
Is this your case that the order is not revisable?
It is revisable.
Then
It is revisable, but after a period of 2 years, I was directed to go back to the revisional authority.
Is there any prohibition or restriction or any legal impediment?
And not only that, the court observed that your limitations shall be considered liberally, taking into account period of pendency of the writ application.
It shall be, my lord.
And
But
you want this High Court to do something which could have been done by the revisional authority.
there was a manifest error of law which I was trying to bring to
That the sub-collector, the competent authority will consider, the revisional authority.
my lordship. But the point which I had raised before the Honorable Single Judge was that
That point can be considered by the revisional authority also.
it can be, my lordship. The only concern was
We will observe that whatever point was raised by you before the writ court shall be considered by the revisional authority. Will that do?
lordship. The only concern was after a period of almost 2 years.
That you have been able to put forth your point. The appellant in the present intra-court appeal has put to challenge an order of a learned single judge of this court dated 24/1/2024, passed in WPC number 31138 of 2022, whereby the petitioner's writ petition has been disposed of in the light of there being alternative remedy under section 59 of the OLR Act full form. 59 bracketed 1 of the OLR Act. So stop. Next. Learned counsel appearing on behalf of the appellant has very vehemently argued that learned single judge ought to have addressed the legal issues raised in the writ petition and writ petition. So stop further. After 2 years of pendency of the writ petition, the matter ought not to have been remanded to the after 2 years, the appellant ought not to have relegated to the revisional remedy under section 58, 59 bracketed 1 of the Act. Stop. Next. We do not find any legal infirmity in the impugned order requiring the appellant to approach the revisional authority under section 59 bracketed 1 of the Act. Stop. We see no reason why the appellant would have been allowed to pursue his remedy under Article 226 of the Constitution of India instead of invoking statutory remedy under section 59 bracketed 1 of the Act before the revisional authority, which revisional authority. Stop. We do not find any merit in the appeal, which is accordingly dismissed. Stop. Next, we however make it clear that the appellant shall have liberty to raise all the legal questions which were raised by him in the writ petition before the revisional authority. Stop further. If the appellant files a revision application under section 59(1) of the Act within 30 days from today, the revisional authority shall liberally consider the question of limitation, keeping in mind the fact that the appellant was pursuing his remedy before this court by filing writ petition and the present intra-court appeal.
Item number 4.
May I please, Your Lordship and VC, I have filed this PIL for for long delay in completion road work in Premnagar area of Berhampur. That road work is going since 2022 November. But till today, that road work is not completed. And on this road, there are many students and many schools in that area. But unfortunately,
What do you want?
for speedy disposal of the completion road work, sir. That work were pending since 2012 November, 2022 November. But prior to that, the road work is also pending, sir. I have also filed a paper cutting which shows that the road work is pending since 2020 March, sir. But the authority did not take any step for completion of the road work. There is limitation. There is also tender was ensured that the work should be completed within 210 days, sir.
So why only this drain? No, why not all the drains in the estate?
So I'm living in Berhampur, that's why I'm filing for
Do you live there?
No, sir, I'm living. My applicant is living on that area, sir. Applicant Simanchal also, sir. We all the public use that road is also cross main road to approach road to NH5, sir.
So who will consider?
Sir.
Behrampur Municipal Corporation.
No, sir. Barampur Municipal also letter to us that they are not the authority to.
All right, someone is appearing for the corporation.
Corporation, yes, I have that letter, sir.
Is someone appearing?
Yes, I think they've,
He has not made Barampur
Corporation a
Municipal
party.
Corporation as a party.
They've already told that they are not the authority to conduct the road work, sir. They will return to us there.
Mr. Counsel, are you seeking any direction against Behram Municipal Corporation?
No, sir, I am not seeking. I have R&D division, sir. Not seeking
Huh?
any R&D division of Barampur, sir. Not, sir, BMC. BMC written letter to us that we are not the appropriate.
Mr. Counsel, are you following us? Are you following our query?
Yes, sir. Yes, sir.
Are you claiming any relief against Barampur Municipal Corporation?
No, sir. No, sir. No.
Then who is to construct the road?
Sir, the Superintendent of Ganjam R&B division, sir. Division 2, sir. R&D division 1, sir.
Yes, do you have any instruction?
no, first time it has been listed, my lords. I don't have any instruction. If your lordship-
Let us have instruction. Let us have some instruction.
Is it the R&B which is to construct lay the road?
Well, the area which is not so strictly within the municipal corporation, but whether
But
the
who
road
is to
belongs to corporation or the R&B division,
To-
not that.
to that extent, can you take instruction
I can take instruction, my sir.
subject to?
You seek instructions and
Yes,
let us
right, my lords. I can
know
take-
what can be done.
Yes,
Who is to lay the road? Let us-
Uh,
no.
4 weeks' time is allowed for the state for London AGA representing the state of Orissa to seek instructions. Or stop. We'll discuss matter on 4 weeks.
Item number 5.
I may please your lordship. The present writ petition is under the PESHA Act, the Panchayat Extension to Schedule Area Act, your lordship, wherein the order passed by the collector under Annexure 13 as well as the notice issued by the Sarpanch under Annexure 14 is under challenge, lordship.
Annexure 15,
14,
14.
1-4. The present factual aspect, your lordship, I'll just state it in a gist, is that the whole district of Mayurbhanj is a 5th schedule area, your lordship, wherein the present village, that is the Anandapur village, falls under the Rairangpur block or Rairangpur Panchayat, under the Rairangpur Panchayat, your lordship. And the same is governed by PESHA Act, wherein the
No, you are
state,
challenging an order dated 11/1/2024.
yes, your lordship, as well as the subsequent notice that was issued
So this order has been passed under which provision of law?
under the PESHA Act, your lordship, wherein we had challenged
The service Panchayat
extension to schedule area Act.
Schedule areas.
So which power he has exercised?
He was directed by this honorable court to consider my representation with regards to the resolution passed by the Gram Sabha.
All right, this time you will not have to file any representation. Let us understand what is this order has been passed under which provision of law?
Yes, your lordship. Under the Panchayat Extension Act.
Which provision? That act is
Section
there
4.
for us.
Section 4, your lordship. Under section 4, subsection I had approached the collector with the resolution passed by the Gram Sabha, resisting the acquisition process made for the establishment of the
Please let us understand, let
Yes,
us
Your
read it. You are referring to I,
I,
4I.
4I.
4 speaks extension of part 9 of the Constitution.
Yes, Your Lordship.
Exceptions.
Have
Four
you
is
understood what you have, the relief which you have sought,
Yes, Your
or
Lordship.
the submission which you are making?
Yes, Your Lordship.
According to you, this order has been passed under 4I. Under 4I.
Wherein it is mandated that the Gram Sabha shall be consulted first before any developmental project is initiated in the scheduled areas, Your Lordship.
Mr. Bhaiya,
Yes, Your Lordship.
my lord wants to know in exercise of which power the order impugned is passed.
Yes. I may be granted some time. I'll examine and
You are challenging an order passed by Sarpanch to the High Court.
no, Your Lordship. My writ petition is in two folds, Your Lordship. If my lord will first peruse the impugned order, the findings or the direction issued in that impugned order, then only the subsequent challenge to the annexure 15 will arise.
4I. How could you refer when we put this question that under exercise of which power this order has been passed, you are taking us to section 4I?
I humbly apologize, Your Lordship. Because of my anxiousness, I have misguided Your Lordship.
Consent was taken. In this case, consent was taken.
I may be pardoned.
Consent of the Gram Sabha was obtained.
No, Your Lordship. Never the consent of the Gram Sabha has been obtained till.
Who is opposite? Come to paragraph 1.
Yes, Your Lordship.
Panchayat meeting was called.
Panchayat meeting was called, but the specific direction of the collector was to convene a Gram Sabha, not a Gram Panchayat meeting. That is also one of my legs of submissions, that such a notice under Annexure 14 should not have been issued, Your Lordship, at the first instance.
As requested on behalf of the petitioner, list this matter on 4 weeks to address the court on the point of law.
I may be permitted.
For him to address the court on the point of law. Unnecessary.
Item 6.
I may be permitted, Your Lordship. A shorter time may be granted. I'll satisfy Your Lordship with regards to all the points.
Sorry, we have other works to do.
Item number 6.
I will plead your lordship. So it is a peculiar case for me. This is the order passed previously by some vested persons. Consequently, the unrequested order passed by the Supreme Court. This is the order passed, my lord, in the garb of public interest litigation. Then, my lord, collector called upon us as well as the report from the Tahsildar. I may bring to Lordship's note, Lordship, page is 261.
Who are you?
We are these small farmers against whom the lease was granted from the year 1975 onwards. I have filed for illustration purposes and to make it less voluminous. I have filed the record of rights of mine from the page 34 and rent is it my level up to 254. Would under the section 3B, lease was granted either in favor of the petitioner or their father since 1975. And we have consequently a record of right on the land in question and cultivating the land for last 50 years. It's got some of the other minor in numbers filed the previous writ application before Lordship, saying those lands belong to government land.
Please come to paragraph 1. Let us understand.
Yes, madam.
Paragraph 1.
Yes, madam.
Petitioners have no personal interest. Is it correct? It is not correct.
Not correct. Yeah, here is the case. The petitioner as well as
come to paragraph 2. The petitioners are public spirited persons of the above noted. You can file a regular petition.
These people cannot afford. That is the
You can afford a senior counsel before the division.
No. I'm a pro bono here before Lordship.
You can appear there also.
I also give me direction. May I suggest one thing, my lord? I have admittedly material from record to show that there is a record of right in my favor.
No,
the same has not been examined by the magistrate collector. So allow the petitioners to ventilate the grievance in the appropriate forum by giving legal aid by the state.
Yes.
That's what I can make a prayer for Lordship, my lord, because they cannot afford. I have all record of rights of mine with me, which let's say another 1 point, my lord. Let's see how they have the collector exercise the mind. Let's see, turn to page 261.
No, we will say that.
Page 261.
Will be provided legal aid.
Legal aid, and the authorities should examine minimum my materials, which are admittedly
that they will do.
That they have the idea. The collector has not done it, my lord. That is my entire case before Lordship, my lord. Has not at all considered the materials which are available in record. On the contrary, so Consolidated says no such materials is available.
Oh.
Therefore, I have a limited prayer for Lordship. Let it grant me leave to even raise the matter before the Tahsildar by giving legal aid by the state. Let the Tahsildar examine. So they are now trying to the eviction proceeding. The collector directed for eviction proceeding.
No,
without examining the documents, which minimum I have filed before Lordship for illustration purpose.
Are you aggrieved by any order?
Yes, my lord. Collector order, my lord.
Collector order? How
yes,
can we?
Page 264.
How can we refer you to Tahsildar?
The collector has asked for the report from the Tahsildar. That I was trying to.
How can we refer the matter to Tahsildar? When the collector has taken decision, then you can.
Any mechanism by virtue of proceedings.
No, is there any appellate authority?
RDC is the appellate authority.
Yes, my lord.
RDC you can go.
Yes, my lord. Bow down to Lordship, my lord. But state should some give legal assistance to the people, my lord.
That we will do. The petitioners have put to challenge an order dated 29/11/2023 passed by the Collector Puri in miscellaneous case number 1 of 2023. To top. The said order appears to have been passed by the collector pursuant to an order passed by this court in a public interest litigation. Passed by this court dated 23/11/2022 in WPC negative CIL number 28352 of 2022. Stop. The petitioners claim to be poor farmers,
Yes, farmers. They are cultivating the land within the recorded right in that favor.
poor farmers. And aggrieved by the said order, they have approached this court by filing present writ application in the nature of public interest litigation. Next, then senior counsel appearing on behalf of the petitioners after some argument seeks permission to withdraw this writ application with a liberty to approach
Revenue Divisional Commissioner.
the
Revenue Divisional Commissioner.
Revenue Divisional Commissioner Puri,
No.
Central
Central Division.
Central Division Cuttack. By filing an appeal.
Yes,
Appeal is there.
yes. He is the appellate authority of collectors.
By referring an appeal. So stop. This writ application is disposed of with the liberty as sought on behalf of the petitioners. Stop. Next. When senior counsel has submitted that keeping in mind the fact that the petitioners are poor farmers who may not be able to ably pursue their matters before the appellate authority without any legal aid, they may be provided with free legal aid.
Legally. Okay. As you said.
Stop. Next. It is observed that the petitioners shall be at liberty to approach the district legal service authority. They can
Cutter.
district legal service secretary, district legal service authority, Cuttack, seeking legal aid, whereupon the secretary legal service, whereupon the secretary
District legal service.
DLSA shall take all necessary steps to ensure that if the petitioners are found entitled to under the scheme, they are provided free legal aid.
High level, deep level.
For order item number 7. May I please, Your Lordship? Turn to annexure 2, page 19 in the interim order.
Yes.
Lordship, page 19.
Yes.
The recipe was granted. Lordship, 4th paragraph.
Yes.
While allowing this writ petition, this court directs the appropriate authority opposite party to grant the benefit of receipt at the rate of 6,600 with effect from 8/5/2015 in favor of the petitioner by undertaking the so and so manner.
Yes.
The RSP scheme says on completion of 10, 20 and 30 years of service, one is entitled to 3 financial obligations. He entered into service on 9/7/84. So he is entitled to 3rd RSP on 6/7/2014.
The delay has been condoned. Delay is
There is a delay.
My lord, delay, my lord.
There is a delay of 201 days for
My lord, the opposite file is hopelessly barred by law of limitation, my lord. There is a delay of 541 days, my lord.
201 days for 204 days delay.
But you have stated in your petition that there is a delay of 541 days. Your
That-
petition,
Yes, ma'am. That
your petition,
that COVID
IA number
that-
3.
yes, I have seen that COVID period will be excluded than 204 days.
No, you cannot do that.
Yes, ma'am. Well,
Yeah. Yes.
My lord, a similar but identical matter was disposed of by this honorable court on 13th March, my lord. Will lordship kindly have a perused this order?
it is on the
A
ground of
similar matter, my lord.
limitation.
Similar matter, will parties are different or
We have referred to Honorable Apex Court order.
my lord?
No,
My lord.
your lordship.
My lord.
No, without the. But 234,
Well,
234,
232,
232, my lord.
232 of
for limitation.
23.
2023,
233 for limitation.
233, 2 for limitation. 232 is for limitation.
232, my lord, is the condition of delay, my lord.
No, you have put your.
Yes, control.
Yes, sorry,
Wrong.
in my file that is yes,
But our
yes.
docket note, if you
List
can,
also 232.
232 of 2023.
IA number 223 of 2020, sorry, 232 of 2023. And WSO and so. Assailing an order dated 28/6/2021 passed by a single judge of this court in WPC number 13840 of 2021. This writ appeal has been filed by the state of Orissa on
I remember, my lord, 20 January, my lord.
1 2023, ma'am.
24/1,
Yes, ma'am.
24/1/2023. Oh, stop. The appeal is thus barred by limitation. Oh, stop. According to their own showing, there is delay of 541 days in preferring the present intra-court appeal. Oh, stop. It has been argued on behalf of argued by Mr. Kotia, learned additional government advocate, appearing on behalf of the appellants that it was because of COVID-19 situation that COVID-19 situation that the appeal could not be filed within the stipulated time. Stop. We, however, find that there is no explanation as to why the appeal could not be filed soon after 28/2/2022. Stop. Following is the explanation, vague explanation given in paragraph 7 of the application seeking condonation of delay. Stop. After having Stop. We are not satisfied with the explanation put forth by the state as noted above for condonation of delay. Stop. As has been held by Supreme Court, movement of file, delay in movement of file cannot be treated to be a good ground for condonation of delay. So we accordingly do not find any reason to condone the delay. IE number so and so. This application is accordingly dismissed. Stop. Consequently, the appeal also stands dismissed. WS.
Item number 8.
Item number 8. Since brief has been transferred from me, my name, Mr. Ashok Kumar Paningrai, may kindly be deleted in the constitution.
Lordships, to have filed a condonation of delay application, however, there is no delay. That application was filed subsequent to the SR raising some objections, but I have already given an explanation as to why there is no delay. And would Lordships have the...
Where is that?
Lordships, this is IA 6547 of 2023. And I have given an explanation as to the certified copy of the order of 16/12/2022 had been received.
So what is the delay?
Lordships, there is no delay. The SR had raised an objection, there's the delay, but however, there's no delay. Though in the prayer, Lordships, the council has mentioned that this honorable court may be graciously be pleased to condone the delay. However, Lordships, if Lordship sees para 1, I have given the explanation has been given as to how there is no delay. Since the SR had raised this objection, we had to file this application.
What is RVPET?
That's the review petition, Lordship. So we've received the certified copy on 22nd of December 2022, and the appeal ought to have been filed on 21st, but 21st, 22nd, 23rd were holidays. So it was filed on the 24th in view of the holidays in the interregnum. So Lordships, there is no delay.
There is no delay.
The original petition was disposed of in 2019.
In 2019, 24th of 29th
So it took
of
some time for review.
No, that's month. 25th Lordships of May, we have filed the review petition.
Yes.
In 2019.
Yes, yes, you have filed, but it took some time for review to be disposed.
To be disposed,
No, but
which was done in 2022.
Your appeal against the order dated 29/4/2019 is surely time barred.
No, Lordships, we filed a review within
All
a period
right,
of 1
that
month.
may be reason why you could not file your appeal during the pendency of review application.
Yes.
That is a circumstance.
Yes. But I mean, we could not file an appeal because the review
That
was
your
still pending.
filing of
before the
review
Honorable
petition will not amount to the exclusion of that.
That will not
that
arrest
period.
the limitation to tick up.
We can condone the delay on that ground, but
Not just in the interest of justice, I would
We can
request
do that.
not just to condone the delay.
No, you should have taken that stand in your.
Ordinarily, that should have been taken. I mean,
You have not
apologetic.
stated anything in your second paragraph
Please.
with regard to
IA number. So the seeking review of an order passed by a learned single judge of this court dated 29/4/2019 in WPC number 22454 of 2012. The appellant had filed RVWPET number 171 of 2019. Full stop. The said RVWPET number 171 of 2019 came to be dismissed
16/12/20.
by an order dated 16/12/2022. Stop. In the present intra-court appeal, the appellant has put to challenge the order dated 29/4/2019 passed in the writ proceeding and 16/12/2022 passed on the review petition filed by the appellant. What's up? Next. Learned counsel appearing on behalf of the appellant has submitted that the appeal against this appeal against the order dated 16/12/2022 passed in review petition cannot be said to be time barred, as soon after getting the certified copy of the order, order passed in review application, the this appeal came to be filed on 24/1/2023. First off, the appeal could not have been preferred against the review order on 21/1/2023 to 22/1/2023 and 23/1/2023, which were holidays. Full stop. Next. Considering the facts and circumstances, particularly the fact that the appellant was pursuing a review application against the order of the learned single judge dated 29/4/2019, which came to be disposed of by an order dated 16/12/2022, this application is allowed. First off, delay in filing of the appeal stands condoned. Yes.
other defects are complete. Other defects are shown.
Other defects.
Other defects
They've all been removed. Not just the.
This has come for admission.
No, orders.
Orders
Defects are to be removed in the registry.
remove other defects.
They, my instructions are they have been removed.
Other instructions that
No, oh, I'm so sorry. I'm so
let
apologetic.
the
I was under the
let rest of the defects be removed within 2 weeks.
within 2 weeks.
2 weeks.
The tagged up matter. There is
single
also-
judge matter. I am appearing for the petitioners. A lot of engineers are there for my lord. They are praying for the Orissa reservation of scale of pay. 1980 it should be applicable to them. In that issue was this connecting matter is related to that. So there is no issue that there is this with writ appeal it should be hard because it is single judge matter. Lordship may delete it because how it is coming in this I don't know. It is not connected.
It's not connected.
Not connected.
No, was it ever prayed before this court for tagging of that matter?
But I don't know how.
Is there any order?
Who is in this case?
I am the petitioner, man. Just transfer between me. I am the petitioner for the petitioners. So many persons are filed.
Which matter?
It may be deleted from the list, my lord. And sister will argue each matter.
PC 2320.
This docket note, office note only shows 15/3/2024. I don't find any judicial order is there for tagging up.
Is no order.
Judicial order, I don't find. No, sir, please.
A subject matter of challenge in both.
Docket note in this. Physical.
Lordship, sir, it could be connected
15/3.
because the
Yes.
subject matter is the
Is same.
That is with
Subject matter
regard
of
to
challenge
the
in both.
Orissa revised scale of pay. Lordship, there is a challenge to that. So probably that is the reason it's been connected with
No.
But the issues are
In absence of any judicial order, it cannot be. Official note shows that certain matter is pending. So how come it got tagged? That is what.
They cannot govern us.
No, देखिए नहीं फिजिकल कॉपी देखिए तो पहले जुडिशियल ऑर्डर पुट है चीज नो मैडम इट इज नो sure
And in that case,
and how could a dealing assistant do this 15/3/2024 office note
therefore, that
petition that was oh at the time of petition সেটা ছিল আচ্ছা
Let the editor will be decide on his own merits. I may be able to pursue the matter with the honorable single judge because it is assigned to single judge. If my lord will.
all right, it will not be taken up together.
the tab of WPC will be dealing from this
Yes.
Would Lordships fix an actual date in the matter? So we'll remove the
First
objection.
you remove the defects, then make a mention, we will see.
We'll do. Obliged.
Obliged.
Item 9.
May I plead your lordship, my lord, in item 9, pursuant to your lordship's last order, I have received today, I have received a affidavit filed by learned EGA, my lord. It is a bulky 90 page. So let it come. May I pray, my lord, let it come day after tomorrow. I will go through the same. And
My affidavit is in my lord's report. I have filed.
Learned counsel for the petitioners, respondent. The respondent seeks adjournment. How many appeals are there?
It's in that case.
In all the cases you are appearing?
my lord, no, my lord, in the first item and last, and two matters, my lord, in first item
For the
and
respondent.
814. And my
Seek adjournment
senior
to
brother,
consider
W801, I'm appealing.
the counter affidavit which has been, consider the affidavit which has been filed on behalf of the appellants. Copies of which have been served upon them recently. stop. List this matter on, when do you want?
Day after tomorrow, your lordship may, if your lordship's convenience.
After tomorrow on possible. 28th. Well.
28th.
28th.
20.
Mr. Rao, do you have Amit Kumar Mishra tribunal's order?
I have given
It is
that.
followed. You have given.
In affidavit, they have given, I am also that, in that case, I am also the conducting counsel and.
Your affidavit has not come on board. You filed a counter.
No,
No, additional.
Additional affidavit. That has not come on.
My lord,
Has it come?
Second case.
Mr.
In the second case.
Yeah.
I will ensure that, my lord. I will take each and every.
No, in our board, it is not
Actually,
reflected.
I have filed one affidavit to be adopted in our case. That is the, because all the back cases I have filed in the second case.
That is in 487 of 2020.
487.
Yes.
That matter may kindly be taken as a lead case.
There also it doesn't reflect. It has not come on board.
Let the additional affidavit. Let the said additional affidavit.
Filed it WA 487.
Placed on record. Let the said additional affidavit filed in WA 487 of 2022 be placed on record by the registry.
Item number 10.
You pick out the appropriate case where entire pleading is available. Otherwise, we will
Yes,
get
this
confused.
case, 487.
What is the point?
Point is, my lord, here the orders have been passed. My lords have been pleased to pass an order relying on a case in the Amit Mishra, in the case of Amit Mishra versus state. Now,
That was confirmed by this court and Apex Court also.
our
And that has been implemented.
to persuade this honorable court is that these people are not covered. So my lord will examine.
Regularization matter.
My lord, regulation. Mobile health unit pharmacists, they are continuing pursuant to the regular recruitment process since last 20 years.
All at once.
Item number 10.
May I please, your lords.
The petitioners are inamdars of village Gochabadi in the district of Ganjam. They are in possession of these lands since their forefathers since 1874. And the land was vested into the state in the year 1954 under the provisions of OEA Act. Therefore, my lord, we being the inamdars, land should have been settled with us under section 8(1). But instead, the Tahsildar.
What is Inam?
Pardon, Mel?
What is Inam?
It's an award, Milos. Conferment of an award by the rule also. In fact, in this case, lordships were pleased to direct my learned friend to file an affidavit to show as to whether the lands have been enclosed by persons or it has been settled with them. My learned seniors filed an affidavit that 37 or 47 persons have been settled with 25 hectares of the land, which he is claiming. There I was directed to file an affidavit in response to his affidavit, whether the fact is correct or not. Then because there is an interim order by this court saying that during pendency of the writ application, if any settlement is made, that shall abide by the result of the writ application. So now I have to in fact respond to my learned seniors affidavit, that I pray also.
Affidavit dated 22nd September 2023.
Where he has given the details of the persons who have been settled with the lands. As per his person, it's illegal because it should not have been done that. Settlement authorities have done this.
Para 4 of the affidavit.
Affidavit. And my friend has also given the details of the persons in favor of whom the land has been settled.
No, land has not been settled. I have said that no land has been settled by the Tahsildar, but the settlement officer has illegally recorded the land.
During the pendency of the writ petition, final order in 2013 was published.
Yes. It is very difficult for this court to entertain your such kind of dispute.
Follow my law.
Come to paragraph 6 of your affidavit at page 53.
During settlement operation, the settlement officer Barampur opposite party number 4 has illegally recorded 25 acres hectares of land in respect of 37 outsiders, and the final order was published on such and such date, my lord. The settlement authority has been injuncted, my lord, by virtue of this order of this honorable court, that any recording shall be subject to result of this writ petition, my lord. In spite of that, the order was communicated to the settlement authorities, but in spite of that, he has said. But the fact remains, he has recorded, and I am to bring it to record, my lord. I cannot file a
question of title that too disputed.
But so far as the other lands, my lord, these are the lands they have recorded. Total land is 300 some odd acres, my lord. 21 families.
No, that is not the question. The question is whether the writ court can go into such disputes or not.
No, your lordship may see there is may state few facts, my lord, if your lordship permits me. The lands are Inam lands, and we have been settled with the land. Not that we have not been settled. And earlier, after settlement with us, the Tahsildar settlement made further settlement 2 acres of land encroaching our land with 107 persons. Then I filed a writ, we filed a writ application before this honorable court 2181 of 2180 of 1981 that decided in 1990. In that case, my lord, the state government has filed a counter. In their counter has specifically said that the land which are in our possession has been settled, and we are not going to encroach upon their land. On the basis of their stand, the honorable court disposed of the writ petition by directing your lordship may see annexure A by 2 filed by the state government, and also I have also filed that, relied on. Paragraphs 3, your lordship may see the state government's affidavit. So, a counter affidavit has been filed, OP number 108 and 109, the state and the Tahsildar, contending while acknowledging that the land which were involved in land encroachment, appeal number 6 of 1964, were settled in accordance with the orders in annexure 2. The orders passed in that case, and now it is annexure 1 in this case. With the petitioners who are found in possession thereof, that the lands which were purported to be allotted to OP number 101 to 107, as described in annexure 3 to the petitioner, are not the same land. That is different land. So accordingly, their lordship, on the consideration of their affidavit, my lord, passed the final order in paragraph 6. Your Lordship may see page 45, running page 45 of this. But so far as the statement made in the counter affidavit that the land settled with the petitioners in pursuance to Annexure 2, that is the order of the subdivisional officer in LE Appeal number 6 of 1964, and the lands now intended to be allotted to OP number 12107 are different from each other is concerned, we find that this writ petition can be disposed of with a direction that no part of the land settled in petitioners in the encroachment proceeding can be interfered with in the garb of allotment of lands to OP number 12107. A position to which the learned standing counsel fairly concedes. It is thus made clear that OP number 108 and 109 are free to go ahead with the allotment of other government land, if any, without any objection from the petitioner, but that in no event the lands of the petitioners are to be disturbed. So this is the final order, and this order has attained the finality and bind.
This order, if this order has been violated, according to you, this order has been violated.
This order has been violated.
Yes, this
order has been violated in the terms, my lord. The land which has been settled, we require the pata in respect of that. ROR in respect of those lands settled in this in our favor. They are not issuing. That is the only crux of the point, and that is the only prayer of mine. The land which has been settled with us, the final ROR may be issued to us. But in their counter, they say that in the meantime, the tahsils have been bifurcated, new tahsils have been created. I have not filed any representation to the new tahsildar. Earlier, I have filed, and the previous tahsil, they could not do because settlement operation was continuing. 2000 to 2013 settlement operation. Because of the settlement officer, they could not issue. Now that is their stand. So now my limited prayer, my lord, in view of the fact that they have admitted and the orders have been passed in the...
So what is the cause of action for you to approach this court again?
Second.
Oh, why? Second, why?
Same transaction.
Why did you file the second writ application?
Because that application, earlier writ application I have filed challenging the settlement of
Mr.
outsiders.
In effect, you want us to implement 1990 judgment by way of this writ.
Perhaps I have been misunderstood, my lord.
No, we are not able to understand. That is our problem.
I'm sorry, my lord. Earlier case, my lord, that 107 persons were allotted.
This we have understood that this order, the order of this court dated 18/1/1990 is in your favor. So what made you to approach the court again in 1999 when the order was already passed in your favor?
My lands, my case in earlier writ application was a portion of my land has been allotted to outsiders.
All right, so that has been that has been decided finally.
They say that this is not the same land.
What is the cause of action?
This is the cause of action is, my lord. In spite of that order, they are not issuing final ROR. Only thing that I want.
Then you could have filed contempt application or whatever.
I have filed, my lord.
Cause of action, even your suit could not have been maintained on this ground that they are not issuing ROR.
My lord,
they are not disturbing your possession. No one is disturbing your possession.
Unless possession is not being disturbed.
Then,
but ROR is not published. So
ROR
is not issuing.
What is ROR?
Record of right, my lord.
Yes, that and we understand full form.
My predicament is this.
Yeah.
Unless the ROR is issued to us, we cannot pay the land.
A lawyer like you can make this submission.
May I plead your lordship, my lord? Your lordship has put me a question that what is the cause of action after that writ application, earlier writ application. Annexure 4 at page 34. That is the fresh cause of action, my lord. After the judgment, we have made several, they have not issued any pata in ROR in our. So we have made a representation to Tahsildar Buguda that in pursuance to the order passed in that land encroachment appeal, we are in possession and land has been there. And please issue pata in our favor. They are not issuing, taking any step. That is in the year 1998. So we filed the writ application in 99 for a direction.
The how many petitioners are there? How will petition? Where is the petition? Where is the petition? Where is the next petition? The petition will find. Yes. Consolidated title. Consolidated is only title. All right.
21, I think.
Yes.
Tuscany. Physical copy. It's coming.
The present writ application filed under Article 226 of the Constitution of India is seeking direction to the opposite party number 2 to issue a final patta in respect of the lands settled with the petitioners / their predecessors in interest in the light of an order dated 10/12/1965 passed in LEA number 6/64 and other connected cases, and to accept rent in respect of the lands described in Schedule 3 of the writ petition. Stop. The petitioners, writ petition was earlier filed before this court. Where is that order? Annexure?
Annexure 1, my lord. At page 11, man.
No, order of this court. This court's earlier order.
Earlier it
We got it. Giving rise to OJC number 2180.
2180. OJC 2180
of 1981. 81.
Yes.
Wherein the petitioners claimed themselves to be the descendants of the, what is this? What is this? The descendants of the Inamdar of whole Inam of village Ghosbadi in the district of Ganjam. Assailing an action of Tahsildar Ghomsur, OP number 109 in initiating several LAC. What is LAC? What is LAC cases?
Any land encroachment of
No.
Land acquisition cases.
annex.
See first paragraph of the order of this court.
Paragraph
18/1/1990.
Annexure A by 2.
This habit of, yes, please tell us what is LAC?
Maybe land allotment cases, I'm not sure because.
What is LAC? Please read the first paragraph.
But so far as the statement made in the counter affidavit.
Mr. Please come to the order of this court dated 18/1/1990.
That I am reading my paragraph 6 of that.
Paragraph 1. We are asking you to read paragraph 1. You are reading paragraph 6. Please.
Para 1.
Para 1.
What is
petitioners who claim themselves
Para 1 of the order, earlier order.
earlier order.
Para 1. LS.
My lord,
Several LAC
para 1, my lord, the petitioners who claim themselves.
What is LAC? L capital A capital C. What does it mean?
Fifth line. LAC.
LAC, my lord. In any settings.
What is LAC?
LEC, land encroachment cases. LAC.
LAC cases for settling small areas of land in favor of the opposite parties number 1 to 107 of that case. Stop. After having, they're not moving.
Committee cases, man.
Land allotment?
Committee cases, man.
Land allotment committee. In bracketed LAC cases. This court, after having examined the claims of the petitioners of that case and the stand of the state respondents taken therein, held as under. Paragraph 6. Stop. It is not the next, it is not the, you are descendants. Petitioners of this case are descendants of the.
Yes, ma'am.
In the original.
No. This writ petition has been filed 9 years after. So they were the petitioners. They were petitioners in the earlier case also in 1981.
We are petitioners here. They are the descendants of the earlier petitioners.
Yes.
My lord.
The petitioners in the present writ petition are descendants of the petitioners of OJC number 2180 of 1981. First off, it is not their grievance that after this court's order was passed on 18/1/1990, any disturbance has been caused to them in peaceful enjoyment of the lands in question. First off, they have, however, come to this court seeking direction to the opposite party number 2 to issue patta, and enter their names in the ROR, record of rights, in the light of this court's order dated 18/1/1990. Stop. Next, the petitioners are, it is admitted case of the petitioners that they are enjoying peaceful possession over the lands in the light of this court's order dated 18/1/1990. First off, the present writ application appears to have been filed for implementation of this court's order dated 18/1/1990, though there is no direction in the said order for issuance of patta or any or entry of the names of the petitioners of the settlees in the ROR. So stop. In our considered view, the petitioners had no cause of action to approach this court by filing present writ application, which is accordingly dismissed. It goes without saying that the petitioners shall be at liberty to approach appropriate forum in case any disturbance is caused to them in peaceful possession of the lands in question, despite this court's observations in the order dated 18/1/1990, passed in OJC number 2180 of 1981.
May I please, my lord? Earlier, we have filed petition before the opposite party number 2, Tahsildar Buguda. In the meantime, the Tahsil have been bifurcated, and now the disputed village comes under opposite party number 5. So now opposite party number 5 has to.
We also make it clear that the issue before the appropriate authority for issuance of patta or entry of their names in the record of rights, which shall be considered in accordance with law by appropriate authority.
Time limit, your lordship?
No.
Item number 11.
Lord, item number 11, your lordship has directed to comply the order which was passed in 2018. And at the same time, your lordship has directed that the chief secretary will furnish the names that who may be responsible for complying the order for initiation of a suo motu proceeding. And on that day itself, I submitted before lordship that we will comply the order. In the meanwhile, your lordship has told me that you file the compliance affidavit. We'll see.
Today, I have filed the compliance affidavit with sketch map and details. And also Chief Secretary has also filed the affidavit in response to your Lordship's order. The compliance affidavit has been filed by the Collector Cuttack, who is the field enquiry officer. And I have submitted my affidavit copy to the other side. So and the Chief Secretary in his affidavit has prayed your Lordship to take a lenient view, not to initiate any proceeding, because the order has been complied in letter and spirit.
Yes.
Well, today, just now they have served a copy on me.
He may file response to my affidavit.
I will file my response. Now the stand has been totally changed. Anyway, I will give my response thereafter. So let's keep it to a week after.
As requested on behalf of the petitioner to consider the affidavit which has been filed on behalf of the Chief Secretary.
Chief Secretary only furnished the names. The compliance affidavit has been filed by the Collector Cuttack.
And the Cuttack, Chief Secretary Odisha and Collector Cuttack. This matter on affidavit.
2 weeks after.
2 weeks.
May in this case, my lords, Chairman Cuttack Development Authority also was redirected to furnish my lords particulars, name of the particulars. We filed that compliance affidavit, my lords, that is there in record. I'm serving a copy to my lord senior my lords.
It has Land Council for the Cuttack Municipal Corporation. Cuttack Development Authority submits that an affidavit has been filed
by the chairman.
By the chairman in the registry, a copy of which has been served upon Land Council for the petitioner in the court itself.
So item 3.
May I submit one thing to your in the affidavit of the Collector Cuttack, he has prayed your lordship that liberty may be granted. We'll file a comprehensive counter affidavit in the that counter affidavit is not been filed. If I will file within 2 weeks, I will file the counter affidavit so that the writ petition can be heard on bail.
In the meanwhile, the Collector Cuttack shall be at liberty to file a counter affidavit in the main writ application. After serving a copy thereof on Land Council for the petitioner in advance.
Let's sub item 3. I'm appearing for the petitioner. That is WPC number 9362 of 2005. Similarly situated persons, a lordship kindly see order dated 18/10/2016.
What do you want?
Well, lordship kindly have a glance at that order. They are directed to calculate the compensation. But till that lordship kindly see.
All the cases are tagged together, and the lead case is Mr. Rao, senior counsel, is appearing in the lead case. If that is decided, all the other cases will be decided.
Lordship, for a moment, lordship kindly.
But the matter is coming on after 2 weeks. Can't you wait till that?
Yes.
Because you have waited for 20 years.
Yes, sir. 2016, order is there.
It's only because of item number order, they could awake.
That is there. That is correct.
Item number 12.
Item 12, I am appealing for the opposite party. Last of them also directed to file an affidavit regarding employment to that period. I am only filed this affidavit and copy also been served. From 2017 to 2022, I am working for a period of 5 years on a security agency.
Yes, who is for the petitioner?
My lord, I am.
What can be done now?
Kindly see for a moment, my lord. Kindly see for a moment.
You are for?
They resigned, they filed the rejoinder affidavit. Annexed, I am for the opposite party.
Who is for the, you are for the petitioner?
Yes.
What can be done now? You are for the, you are central government. You are the central government.
Yes.
You have not implemented the order.
No, we have challenged this, my lord. I kindly have a glance to the page 43 of the brief. Page 43, my lord.
Page?
43.
43?
Yes, my lord.
What for?
The order passed in the OA 607 of 2001.
Yeah.
May I place, my lord?
Yes, please.
The applicant was not found suitable for the post of aircraft assistant. Thereafter, he was given an offer.
No, where you are reading 43?
Yes, madam. 43 of the writ petition.
43 petition, MA petition.
Main brief, 43 of the brief, madam, running page 43. The annexure 3 of the writ petition.
This is page 42, my lord.
42.
The order dated
Page 40.
42.
42, yes.
The applicant was not found suitable for the post of aircraft assistant. Thereafter, he was given an offer for the post of cook, and again he was not found suitable for the post for the said post. Thereafter, he was given an offer of employment at Safaiwala sweeper, but apparently the applicant did not agree for such offer. However, with the instruction from the respondent, Mr. B. Das, Learned Additional Standing Counsel states that the applicant shall be given an offer for employment within a period of 1 month from today. And Mr. Rath, Learned Counsel for the applicant, states that the applicant is now ready to take an employment if suitably offered. That is the post of gardener, Mari or peon, such similar posts. On the face of the undertaking of the parties, this original application is disposed of no cost. Thereafter, my lord, last para, while disposing, copies of this order be handed over to Sri Rath, Learned Counsel for the applicant, and Sri Bidas, Learned Additional Standing Counsel, appearing for the respondents. While disposing of this case, Learned Additional Standing Counsel is requested to exercise his good offices to resolve the problem outside of the court as expeditiously as possible, madam. Thereafter, madam, kindly have a glance to.
So this is the order which you have challenged.
No, madam. Thereafter, another order was passed, which was on the challenge, madam. That is at page, madam, 57. 56 it starts, madam. 55. Yes, ma'am. Yes, ma'am. Second para, despite the aforesaid repeated orders dated 15/5, second para, madam. Problem. Yes, ma'am. Operative portion, madam. No, ma'am. 57, second para last. Second para I am placing, ma'am. Despite the aforesaid repeated orders dated 15/5/20 rendered in OA number 507 of 2001, respondents have not to provide the group D employment to the applicant as yet for which the applicant has filed the present MA. And after disposal, he has filed after 2 years and MA was filed for implementation of the order, madam. And in this disposal matter, OA number 607 of 2001, in the objection filed by the respondent in MA 597 of 2003, it has been disclosed that only 5% vacancies have been earmarked for providing compassionate appointment, and therefore the respondents have not been able to provide an employment on compassionate ground to the applicant in Group D post. Cause of action in the present case having arisen long before the imposition of 50% condition, such an objection is not sustainable, and the respondents are bound down by their own undertaking given repeatedly, and as a consequence, respondents are hereby directed to provide a compassionate appointment to the applicant, and in the peculiar circumstances of this case, a time limit is of 90 days is hereby fixed, by which time the respondent should provide a compassionate appointment to the applicant in Group D post, so that he can himself, his family from starvation. MA number 50597 of 2003 is accordingly disposed of. This order was under challenge, madam. Thereafter, madam, kindly have a glance. We have given 3 offers to the applicant, and we have considered also his case, and he found not suitable, madam. And lastly, he was offered the post of Safewala. He did not, madam, choose to accept, madam. And kindly have a glance to page 74. Madam, the office memorandum dated 5th May 2003, madam. Paragraph 3. The maximum time, I got it. The maximum time a person's name can be kept under consideration for offering compassionate appointment will be 3 years, subject to the condition that the prescribed committee has reviewed and certified the penurious condition of the applicants at the end of the first and the second year. After 3 years, if compassionate appointment is not possible to be offered to the applicant, his case will be finally closed and will not be considered again. But despite that matter, we have considered, and he found not suitable. Another thing is that matter, in my affidavit, what last occasion I have mentioned before your lordship, this honorable court matter, kindly have a glance to page 32 of my affidavit, said affidavit dated 25/9/2023. In similar circumstances, matter, this honorable court was pleased to allow the writ petition filed by Union of India, matter. Kindly have a glance to that order.
Where is that?
My lord, I am pleased. Para 2, my lord. By way of this 6/1/2005, affidavit dated 25/9/2023, my lord.
25/9/2023 affidavit. Internal page 34, ma'am, of that affidavit. Yes, ma'am. Yes. Affidavit internal page. Affidavit dated 25/9/2023. Nothing is there, ma'am. Yes, ma'am. Page 34. Yes, ma'am. 25th. Yes, ma'am. Suresh Kumar, ma'am. Suresh Kumar, ma'am. This honorable director is there. And page 34, ma'am. Yes, ma'am. Of that affidavit. From the last second page, ma'am. WPC number 3598 of 2007. Order of disposal. I got it, ma'am. Annex 10. Yes, ma'am. And paragraph 2. May I place, ma'am? Yes. My paragraph 2. By way of this writ petition, the petitioners have challenged the order dated 6/1/2006 passed by the Learned Central and State Tribunal, Cuttack Bench, Cuttack in OA number 36 of 2005. The fact of this case is that the father of the original applicant expired in 1982. Thereafter, a case was filed for compensatory appointment in 1991, and the same was rejected in 2004. Prior thereto, he had approached the tribunal in 1996. The present proceeding was initiated in 2005, and the same was allowed by the tribunal. Being aggrieved by the impugned order, the petitioners have filed this writ petition. Then, counsel for the petitioner contended that on 23/7/2007, this court passed the following order, madam. And issue, yes, ma'am.
Lordship.
Thereafter,
Kindly see the region. Kindly see the region. Though they have admitted that I am in serial number 2, kindly see page 27 is now 54. Your Lordship. There is, kindly see the region rapidly. 90. 16. India 90 is died. 16/11/1990. Lordship, for the particular period, I have given the affidavit that in 2017 to 2022 in a private security agency. Agricultural land there, cultivating other property, landed property. In their affidavit, they clearly stated that they have not given a single employment in the rehabilitation scheme, my lord. Can you see their affidavit, my lord? No, my lord. No, my lord. Kindly, therefore, is say that. Page 27, kindly for a see, my lord. 27. Annexure 12.
It can be done now.
Kindly see page 4 of their regional rapid inventory.
Yes, we have understood. Tomorrow we'll pass.
Your lordship.
Item number 13.
Public.
Now, this case, the violation of section 7A and section 3B of the Orissa Government Land Settlement Act is under challenge, my lords. Last occasion, lordship had directed me to respond to it, not file a small affidavit. I've already got the instruction, lords. I need only 2 to 3 days time. I've prepared the affidavit for filing that affidavit, lord.
Yeah. Let you file it actually, if you want to file.
Yes, last date was said pass on 12th of March 2020. Item number 14.
Interim order is there, but
Only a small prayer, let them serve an advance copy so that we can also reply back to the same. Yes, I will do.
Item 14.
14 actually. Lord, item 14. Here in the first case, petitioner is the workman. In the second case, and Lord, senior appears for the management. Both of us have challenged the award. He has challenged, management has challenged the award that a reinstatement in the service. I have challenged that is only that portion of the order where back wages has been denied. So first is to argue whether reinstatement is correct or not, because that is management case. This first case, the workman's denial of back wages depends on that case. I think the region does that.
You want WPC 14423 of 2014 to be addressed first.
Because in that, my fate depends on that case.
You are for workman, he is for management.
Management. Right. Or if your lordship kindly see the award itself.
You are pressing 14423.
Yes, but 14423 of 2014. Possible. Yes. The application is at page 9, Malad, Annexure 1. The workman admits that he was appointed as a mate. Where? Paragraph 1, Malad, if your lordship looks at Annexure 1, page 9. Yes. He was working as a mate. Yeah. The work is not of permanent nature, it's a temporary appointment. He is a DLR, Malad. DLR, Malad.
Daily rated. Labor rated.
Daily labor rated, that is on daily wage basis. Daily wage rated.
he was not appointed through any process of selection. There was no sanctioned post in the corporation, my lord. They were appointed as and when it is required. And the reference that was made, if your lordship looks at page 14.
He's a typist.
Page 14.
He's a typist.
DLR typist. Subsequently, he was also asked to do some typing work.
Typist engaged on daily wage basis.
Right.
And his he was supposed to work for you as and when required.
As and when required, it was actually temporary assignment through contractual appointment. The reference is whether the action of the management in refusing employment to Sri Ganeshwar Pandya, DLR typist, with effect from 1/10/2000 is legal and justified. But since 2000, he has abandoned the work. That is our case. He approached the High Court in a writ application in 1999. That writ application was eventually dismissed. Then he approached the labor authorities on section 33C2 for back wages. That was also refused. Then he approached the government for re-employment and the reference was made. But since 2000, the reference made in 2012, he approached the labor authority in 2007, a delay of 7 years. So he was not in service, admittedly, from 2000 till today. There is no sanctioned post. But if 25F has been violated, he could have been compensated. He is now aged about 59 years at present. If you also look at the award itself, it's on a hypothetical basis, the award has been passed. Page 16, if you also look at the stand taken by the corporation, the first party management in its written statement, page 16.
Paragraph
3.
Thereafter, the workman.
The first party management.
Internal page.
Page 16 of the award, Marad. Of the writ petition.
Page 4 of the award, but that continuous page is 16 once.
Inner page 4.
Paragraph
3, Marad.
Yes.
The first party management in its written statement challenging the maintainability of the case on the ground of initiation limitation as the second party has raised the dispute after a lapse of 7 years, has further stated that the second party workman was never engaged by the first party management and he was deployed by a labor contractor and was paid by him. The payment of contribution under EPF scheme was made because of its mandatory in nature. It doesn't establish employer-employee relationship between the first party management and the second party workmen. Refuting the claim of the second party workmen, he was engaged under BCDDA 2. That's a ancillary work that was given in different projects from 1789 to 39/2000, and it is stated that he was engaged through contractor, and while working as such, he abandoned duty since 1/10/2000. Therefore, in no circumstances is the case maintainable. The second party workman is entitled to the relief claim of the present proceeding. But the issue was framed at page 17. The findings in issue number 2 at paragraph 7, it says in this case, when the second party workman challenges the refusal of employment with effect from 1/10/2000 as illegal, the stand of the first party management is that second party was not its employment. He was engaged through labor contractor. While working under contractor, he abandoned the duty with effect from 1/10/2000. To substantiate his claim as an employee under the first party management, second party workman has filed document as Exhibit 1 series, the copies of attendance sheets. Well, wherever he works, even in the projects, attendance sheets has to be taken by the labor contractor on the attendance sheet of the corporation. Exhibit 2 series, the copies, the muster rolls. Exhibit 3 is the copy of the letter dated 31/8/95 issued by assistant engineer. And Exhibit 11, the copy of particulars of PF statement of Ganesh Pandey, ex-DLR typist. In rebuttal to the aforesaid document, evidence on record, the first party management clarified that muster roll is being maintained as per the Orissa Contract Labor Regulation and Abolition Rules 1975. The relevant portion which speaks as follows: the principal employer shall ensure the presence of his authorized representative at the place and time of disbursement of the wages by the contractor to workmen. It shall be the duty of the contractor to ensure the disbursement of wages in presence of such authorized representative. Sub-rule 272, the authorized representative of the principal employer shall record under his signature a certificate at the end of the entries in the register of wages or the wage cum muster roll as the case may be, certified that the above amount, the amount shown in column so and so be paid to the workman concerned in presence of the presence in my presence and so and so. Similarly, as per Employees Provident Fund and Miscellaneous Provision Act, contribution is to be paid in respect of every employee engaged by or through contractor. Hence, neither muster roll nor provident fund do not establish the employer-employee relationship between the first party management and the second party workmen. On perusal of Exhibit 2 series, copies of the muster roll, it is found that the certificate given by disbursing officer of the second party workman was DLR, which is contrary to the stand taken by the first party management. Well, that is our stand, is a DLR. There is no such provision for appointment of DLR, and the payment has not been made directly to the second party workmen by the first party management. Later, Exhibit 3 reveals that the second party workman has been designated a DLR typist under first party management. The EPF statement on Exhibit 11 reveals that second party workman is an ex-DLR typist. Regarding his explanation furnished by the first party management in its written argument with reference to Rule 72 of the Orissa Contract Labor Regulation Abolition Rules and the provision of Employee Provident Fund and Miscellaneous Provision Act, it is found that such provision of the rules envisages that endorsement of the payment of the worker through wage cum muster roll to be certified by the principal employer to have been paid in presence of representative, but there is no document furnished by the first party management to show that such amount of EPF has been paid by the first party management on behalf of the contractor, nor it has been furnished any document to the effect that second party workman has been paid through the contractor. Therefore, in the absence of such document furnished by the first party management, in view of the document filed with the second party Workman regarding payment of wages through muster roll, Exhibit 2, the letter of Assistant Engineer Exhibit 3 and EPF disclosing the name of second party Workman, ex-DLR typist, lead to conclusion that second party Workman was working as DLR under the first party management. But there is no dispute about it. He was working as a DLR typist. There is no sanction post. And he abandoned from 2000.
This is admitted.
Sir, he says, the tribunal says, presumption is that he has not abandoned, presumption that he was continuing, and he has been denied the work.
No, but from 2000 to 2007, what
Right.
was he doing? Was he getting some emolument?
So he was not working anywhere. He has not filed an affidavit what he was doing. Law says the workman has to file an affidavit whether he was gainfully employed somewhere else or not. But he has not filed anything, any document. In 2007, he approached.
But is this an admitted fact that from 2000, he was not working with you?
Yes,
This is admitted.
he has admitted.
And where is this decision of Supreme Court?
The Supreme Court decided that people are kind of say 7 years after.
Reference cannot be gone into.
Sir,
Validity of reference cannot be gone into by the tribunal. Where is that decision of Supreme Court?
sir, delay is one of the factors which I'll bring your lordship notice in the Supreme Court says. Supreme Court says, delay. Well, our constitution.
No, that judgment has been referred to in the.
No, that has not been. That has not been.
One judgment has been referred to by the tribunal.
2008 116 FLR 237, that is currency. That is what.
The tribunal has referred to two judgments also.
At page 10 of the award.
While answering letter number 1, the tribunal has referred to the decision.
The tribunal has referred to that Karan Singh's case, that executive engineer versus. It says that the tribunal has no authority to invalidate the reference, particularly when it has been found that order of termination violates 25A of the Industrial Dispute Act. But this judgment is applicable if it is established that 25F has been violated. I would like to bring your lordship's notice the 2005 ACC, that Madhyamika Shiksha Parishad UP decision. Let me kindly have a look at that. First point is there is no sanction post merit.
What did he do after 2000?
So that he has not disclosed actually.
No. Did he approach any forum? After
No, he approached the High Court in 99.
Thereafter?
That was dismissed.
Thereafter,
Then he approached the tribunal on a 33C2 for wages.
when?
That was in 2007 or 8, 7, I think.
Before that, he
2007.
did not approach.
2007.
Before that, he did not approach any
No.
forum between 1967 and
No.
2007.
2007, that was also rejected.
It was rejected.
My lord, may I interrupt? One
Yeah,
minute.
that's your case.
Yeah, that is my case, that there's no sanction post and he abandoned the work. He did not work actually in the corporation. He was a temporary employee like DLR. Therefore, he was not employed with due process of law. And therefore, question of reinstatement doesn't arise. That is one of the main points we are saying, Bharat. And the tribunal has denied wages because he has not worked from 2000 to till the filing of the reference. But I refer to, your lordship, kindly see 2005 volume 5 SCC 122.
102.
Yes, madam. Paragraph 4 and 5, if you also looks at. Respondent challenged that discontinuance of its service in the rate petition from the order in these appeals. High Court was persuaded in view of the respondent of casual workmen who had completed 240 days of work that preparation of the certificate was referable to certain statutory obligation of the employee, and the discontinuance of the service of the respondent was not legal, that they were entitled to reinstatement. According to High Court, director appeared to take respondent back in service as casual worker and continued their service upon payment of wages admissible to the regular employee during similar work. High Court further directed the respondent to be considered for regular appointment at lower division clerk, and as and when posts were filled up, and the basis of qualification, seniority as daily laborers, and the service of the respondents shall not be dispensed with till they are absorbed on a regular basis. We are unable to afford the order of the High Court. There was no sanctioned post in existence to which they could have been appointed. The assignment was ad hoc, on which anticipatedly spent its out. It's difficult to envisage them for status of workmen as analogous from the provision of the Industrial Dispute Act, imparting the incidence of completion of 240 days work. The legal consequence that flows from the work that duration of the Industrial Dispute Act are entirely different from that by the implication is attributed to the present situation by way of analogy. The completion of 240 days work doesn't, under law, import the right of regulation. It merely imposes certain obligation on the employee at the time of termination of service. It's not appropriate to import and apply that analogy in extended and enlarged form here. That is how the court has analyzed. If your lordship knows that Umadevi is.
No, but Mahadevi, that is not right because this judgment has no application. In this case, the matter had not gone to the tribunal.
No, it has not gone to the tribunal. It has not. It directly they approached the High Court.
That background, the decision of the High Court was interfered.
But only thing, the principle of law, what analogy I'm saying, what the law decided here is that there is no sanctioned post. I just want to emphasize on that. Facts are different, Maran. They directly approach the High Court.
The paragraph makes very clear. It is difficult to envisage for them the status of workmen on the energy of the presence of the idea.
Right.
Importing the incidents of completion of legal consequences that flow from work for that duration under Industrial Dispute Act are entirely different. So therefore, this judgment will have no application.
The only thing I wanted to submit that, but same thing is Umadevi's case also.
That's how.
But let's we kindly have a look at that Judgment Umadevi's case, there is 45.
Umadevi, no application.
But
Simple question is.
Right.
As to whether finding reported by the tribunal.
Right.
That he was wrongfully retained, sorry, not allowed to
Right.
terminate. Does that correct? That is correct or not? And whether he was entitled to whether the finding of the tribunal is correct. Umadevi is a regularization matter.
Regulation matter. But that also says about the status of temporary employee. That's exactly I wanted to say. There is no sanction post, no selection process was there. But here, if your lordship looks at, but kindly look at page 21 of the award. Page 21 of the award.
Yes.
So paragraph 8 only deals with, from page 20 onwards, is a refusal to join in service. There is no material is there. Lord. When the second party workman has claimed, para 8 at page 20, para 8. When the second party workman has claimed that he was refused employment with effect from 1/10/2000, the stand of the first party is that he was abandoned with effect from 1/10/2000. In course of a plea, of course, with a plea that he was engaged through contractor. Since the stand of the first party management to the effect that second party workman was engaged through contractor has not been negative, it has been held that he was engaged as DLR under the first party management. The first party management failed to produce satisfactory steps to substantiate the abandonment into service by way of notice served on the second party. The same is not acceptable. This is the only finding that has been given.
We'll see. Anything?
My lord. What my lord senior? My lord.
Judgment shall just right. The judgment of Reserve Bank of India. Let's kindly have a look at that judgment. Paragraph 17. The finding of the court, Madam. This is a case of reference. Central government referred the matter.
Yes.
We have carefully considered the rival submission made by the learned counsel appearing for the respective parties. The learned senior counsel appearing for the appellant and second.
You are referring to which paragraph?
Para 16, 17 is the finding. Para 17, Madam.
Yes. Yes.
In our opinion, the High Court has committed patent error in allowing the writ petition filed with the respondent therein, who is a daily wage worker, when it was not established that he was working on regular basis. The High Court, in our opinion, is not justified in directing that the respondent one must be reinstated and appointed in a similar post. The High Court has also clearly erred in examining the legality of policy and giving relief solely on the ground that it was found the policy and action of the appellant contrary to Article 14 and 16 of the Constitution. It is pertinent to notice that the High Court has taken into consideration the entirety new aspect which was neither pleaded by the petitioner in the writ petition before the High Court, nor was claimed by the claimant statement filed with the tribunal without giving an opportunity to the parties.
This will have no application in your case for the reason that here the his claim was rejected by
under the ID Act.
Tribunal
By the
rejected.
tribunal, and thereafter he got.
High Court reversed it.
And the High Court interfered. In that circumstance, the Supreme Court said, no. The High Court
Here,
could not.
sir, one of the question here was delay in reference.
Yes.
Delay in reference is one of the aspects which actually we wanted to bring a lot of notice.
Para 20.
Paragraph 19, 20, Marad. 20 actually, this court held that even though there is no limitation prescribed for reference of dispute to an industrial tribunal, even so it is not only reasonable that the dispute should be referred to as soon as possible after they have arisen and after conciliation proceeding have failed, particularly so when dispute relates to discharge of workmen. This court has held that delay of 4 years in raising a dispute even after re-employment of most of the old workmen was held to be fatal. In so-and-so case, this court held that delay of 7 years to be fatal disentitled the workmen to any relief. In our opinion, a dispute which is stale would not be a subject matter of reference.
Yes.
Sir, another decision is to 1994 Supreme Court.
Yes. Yes.
This is page 1638. AIR 1994 Supreme Court 1638.
Yes.
Paragraph 3 and 4.
Yeah, and the 33 and this is about regularization.
Sir, regulation heading is there, but actually it's a discontinuance. It's a case of discontinuance after completion of 240 days work and this violation of 25F. And the Honorable Court has said, we are unable to uphold the order of the High Court. There was no sanctioned post in existence to which they could have been appointed. But here, if you also kindly appreciate, that 99 a writ application was filed, as you told your lordship, that is OJC 9103 of 2007, mentioned in paragraph 7 of my writ application, that was disposed of on 27/7/2007.
Yes.
There also the question of discontinuance was not the subject matter. Then ID Miss case 87 of 2007 was filed, 33/7. There the question of only back wages. Then reference was made in 2012.
All right. Yes.
And he is now 59 years, or something, maybe approaching 60.
May I please? The lordship to see what are the irregularity or illegality committed by the presiding officer, Industrial Tribunal. My humble submission before your lordship.
No, the order of the tribunal is correct. According to you, to the extent
my lord, that is correct.
your reinstatement has been ordered.
Right.
All right, back wages has wrongly been denied.
My lord, and your lordship, the point of law involved that it's 7 years delay. That is also not correct. Your lordship will see. I just now noticed that the LCR has not come, but I have that record that in the claim petition, Workman has elaborately stated that there is no delay because in the year 1999, I filed the case before the Honorable High Court for regularization of my service and equal pay for equal work. That case was had, and order was passed in the 2007, your lordship, and that is your lordship. That was last. I will not take more time, your lordship will see. We should, for instance, your lordship, the grievance of the petitioner in this writ application is that The senior working under the opposite party are retrenched like that of the petitioner who is also senior man, but the juniors are allowed to continue in service, which is stoutly denied by the learned counsel for the opposite party. In our considered opinion, all these aspects can be taken up by the Industrial Tribunal under the provisions of ID Act 1947. If so, advise the petitioner may approach the appropriate forum. The writ application is disposed of accordingly. So the question of delay does not arise. Thereafter, your lordship, for this intervening period, this workman filed a case under 33C2 of ID Act. In that case also, as these are disputed question of facts, for that reason, liberty was given to approach the presiding officer in the Industrial Tribunal. So question of delay does not arise. And your lordship will see that is what my lord is senior said, that all along that is case of Uma Devi relates to regularization service of irregular recruit. My lord, lordship. And your lordship will see the reference that is, your lordship will see when this petitioner approached the labor machinery, the district labor officer, that is also in the 2007. Thereafter, conciliation was going on. When conciliation failed, thereafter reference was made.
That they have understood.
My lord. So, in your lordship, my submission before your lordship, there is no delay, and the plea taken that is Uma Devi case will help the management. That is also not acceptable. And so far as my grievance, your lordship, in the first writ application, your lordship knows that it onus lies in the workman that he has to lead evidence that he was not in the gainful employment. Now your lordship is to see whether such evidence and whether in the examination of chief I have stated or not. That is, I was not in the gainful employment during this period. That is, your lordship in the LCR, your lordship will see, and also your lordship see examination in chief by way of affidavit I have filed.
So why are you doing this? You are filing this affidavit,
because
file an affidavit or filing. It's not the way.
No, your lordship.
If you have to file the document, you file that in the registry.
My lord. Your lordship, I was under the impression LCR might have told. For that reason, your lordship.
But High Court rule says if you want to
My lord,
file,
your lordship.
that has to come by way of amendment.
Sorry, my lord, I was the impression because the LCR might have called.
Affidavit after affidavit, how can we take on record while passing the judgment also? You have to take the recourse of amendment instead of doing that.
Your lordship may call for the LCR, your lordship can see that that is whether such a plea has been.
See, whatever the materials are there, we will decide.
So my submission, one minute, your lordship. That is all along, that is pleading was made that I was not in the gainful employment.
All right.
Yes.
Item 15.
Number 2 and 3 are filed an affidavit. I replied to it more time. OP2 and 3.
And counsel appearing on behalf of your
Petition.
petitioner states that he has received a copy of
Affidavit filed by OP number 2 and 3.
an affidavit filed on behalf of opposite party number 2.
2 and 3. 2 and 3.
2 and 3. First off, to consider the said affidavit, he seeks adjournment. First off, as requested, this matter on 2 weeks.
Item number 16.
Interim order to continue.
Interim orders and continue in the meanwhile.
16.
And for the respondent.
Your Lordship,
Mr. Pulkia was allotted the brief, he is in court number 6. May I kindly?
So tomorrow we will take up
yes, ma'am.
or on Wednesday. When Thursday,
My lord.
as requested on behalf of the estate. The old matter is pending.
Item 17.
May I please, members? All these cases, my lord, relates to all the petition appointed as resource teacher, my lord. By way of facing regular selection process by director of teacher educator and posted to different primary schools with regular scale of pay. Way back in 92 to 93, they are appointed. They are given all service benefits, including GPF number and pay revision also, as a regular employee, my lord. What happened? 1995, some of the resource teachers were transferred from director teacher educator to the director of elementary education. But while transferring them, they were treated as a fresher to that elementary cadre. They approached my tribunal. The grant of seniority and pay fixation, pay protection. Tribunal allowed all the cases.
So you are challenging which order?
We are challenging the order part in review petition. Annexure 15, page 134.
So you are not agreed by the original order?
Original order was in our favor. But on all the cases, thereafter, my lord, the order allowed all the cases in 1996, 2011. Some cases are also filed. That matter was approached by challenge by the opposite parties before this court.
There was an SLP filed.
SLP filed. All SLP dismissed. Kindly see page 129.
Then
Annexure 14. After dismissing all the SLP, and kindly page 129. Government directed that all the ex-resource teachers shall given all benefits. Those are approached, my lord, and approaching by the tribunal, confirmed by my lord, and confirmed on appeals court. That is page 129, my lord. Kindly see.
129.
My lord. 129 government passed the order after dismissal all the SLP in similar matter. Directed the director elementary to what is
where is the order impugned?
Impugned, my lord, thereafter, my lord. All these orders are produced, impugned, my lord, 134, my lord. Review petition filed by the state. We are pressing annexure 14, page 129, because in similar matter, government, after dismissing all the SLP, government directed to the director elementary to give in all service benefit to the ex-resource teachers. That is page 129, my lord. And 130, the list has been given. 130. The list of cases has been given, my lord.
Where is the judgment?
My lord, judgment, yes. That judgment, my lord. Thereafter, we approached Land Tribunal. Land Tribunal given our finding in our favor. Thereafter, some cases were filed in 2019, 2015. In that case, also Land Tribunal given the benefits. Kindly see page 74. This order of Land Tribunal was challenged before my lord, division by the division bench, page 74, my lord. Kindly see. Operating parties, my lord. Page 74 is judgment of this court. Page 74. Challenging the order of Land Tribunal. Your lordship, my lord, decided that they are covered by the earlier order, so writ are dismissed. That is, my lord, kindly see last operating part. My lord, page 82, operating part. Page 81, last operation, last part, my lord. 81, can see page 81. Paragraph 2. My lord, paragraph 2.
No, let us be clear about the facts.
Yeah, right.
There was.
We were appointed resource teachers. I have given the all written note submission flag Y, my lord. It is written flag Y.
Letter from the.
Yes, I have given the written note, flag wise. The, if,
So an application was filed before the tribunal.
my lord,
What is the number?
that is my lord, batch of case, that is my lord, OA number, page 50, OA 3251 of 2011 and batch.
OA number
3251, C by 11.
3251.
1. C by 11. C Kotak bench, my lord, Kotak bench.
C by 11.
Batch of case were filed.
So this was filed by the teacher.
By the teacher, though, by what happened in 9
by teacher.
teachers.
So this OA was allowed.
Allowed.
Then writ applications were filed.
Writ applications filed. In this, in one writ petition are dismissed. Other writ petitions, my lord,
Writ petitions were filed. By state.
By state.
One dismissed.
Now, writ petition was filed. That are during pendency of writ petition, some other cases are filed also by tribunal allowed some cases. Their cases, they are also challenged before this court. Some other similar place teachers, they approached my lord in 2015. During pendency of writ petitions before this court, 2017. This all the original are also allowed by land tribunal. That was challenged by the opposite party in the annexure that I given my lord. That is my earlier given page 80, order of High Court. That was challenged. That is my lord, page 74 is starting. Operating parties, my lord, page.
So orders passed by the tribunal were challenged before the High Court.
My lord.
All of them. And all the writ petitions filed before the High Court were heard together.
My lord.
So which is that order? Which is
that is my lord, not separately hard, my lord. Separately hard.
Separately.
My lord. That is my order at page 74.
74.
74.
This was decided by a division bench.
My lord. To which honorable single judge is also a party. The party review order. Division bench. Sorry, my division bench.
Okay.
Sorry, division bench.
The division bench had dismissed.
My lord.
Dismissed the.
And writ petition.
What is the date of order?
Date of order, my lord. 13/3/2020, my lord. 13/3.
2020.
My lord.
Thereafter,
SLB preferred. Page 83.
Dismissed.
Dismissed.
Thereafter, review.
Thereafter, no review. Thereafter, review has filed. Yes, review has been filed by the government. Page 84. In that case, page 84.
Review order is at this place, which page?
In that case, my lord, review order is at page 84, my lord.
84.
My lord.
Mr. Mahanti,
My lord.
after the tribunal being abolished, that review petition came before the learned single judge.
My lord.
We were under the impression that the learned single judge has reviewed the orders passed by the revision bench of this court.
No, my lord. We are of the, what happened? We approached the tribunal, similar matter allowed the case. During pendency of the case, that is also, my lord, kindly see annexure page 59, same order, the Lord Tribunal was dismissed by the division bench. That kindly see page 69. Order of Lord Tribunal, the same order which was under challenge in the review. This one will dismiss the matter. That is also produced before the honorable single judge. Kindly see page 69. The order dated 18/5, same order, my lord. Kindly see page 69.
Yes.
The order under annexure 4 by passed Lord Tribunal was challenged before decision court in one of the original application. That is, my lord, where number. This honorable court in Basundral Mr. case dismissed the petition. The order dated on 28/9/2015, which is reviewed by the honorable single judge. The order dated 29/8/2015. By batch of cases, one of the cases was challenged before the decision court in annexure page 69 in WBC number 23915 of 17.
No, what for you are showing us this page 6?
The order of Lord Tribunal, which was reviewed by the honorable single judge. That order was in the read petition 5. No, sorry. One common order was passed by a batch of read petitions. That is my date is 28/9/15.
Mr. Mahanti, we are failing to understand. WPC 631 of 2019.
My lord.
That was against an order of learned tribunals.
My lord.
So, where is this order?
That is
631 of 2019.
That one I given, madam. That is my lord, page 74. Page 74. In another matter, similar matter, page 74.
In respect of some other person.
Other cases of similar ex-resource teacher. Those are observed subsequently in primary school teacher post.
OA number 38660C of 2015.
And batch.
And batch. This order of the tribunal was challenged before this court.
My lord.
By
the state government of opposite party, and it was dismissed.
Where is this order? Tribunal, which was confirmed in 13/3/20. 386160.
My lord, that is my lord. At page 95, sorry, 94, annexure 7, page 94. '96 is starting. Order passed by operating parties, my lord, at page
3860, yes.
My lord. Operating page 106, 106.
So you say that this page 94 order,
my lord,
that is 3860,
my lord,
that got confirmed in division bench of this court.
My lord.
So thereafter?
Thereafter, government after challenge on appeal court, SLP was also dismissed. Thereafter, government granted the benefit. My lord.
There was an order passed by the
Tribunal,
tribunal.
my lord.
There was review application filed for review of that order.
Yes, my lord.
So whether that order of the tribunal was affirmed by the High Court?
Yes.
Where is that?
That I'll just now showing my lord. Basanti Mr. Case, my lord. Look at that, I'm showing my lord. My lord, page 69, my lord. Page 69.
Which order was passed by the tribunal?
Tribunal order was, my lord, passed by that. And page 50, way number 3215 of C of 11.
Way number?
Way number 3215 of 11. And the one of the order of challenge, Basanti Lata Mishra, my lord, that is serial number.
Way number 3215 of 2011.
And batch.
And that
My
was
lord.
disposed of on?
Disposed of, my lord, on 28/9/2015. 28/9, my lord.
2015.
My lord.
The review was filed against which order?
This order.
And writ petition was also filed against this order?
Yes.
Huh?
All the against this order, writ petition filed. In the one writ petition dismissed. Other writ petitions, your lordship decided that you may file a review. After granting a permission by this one, they filed the review.
So it is not that this court affirmed the order of the tribunal.
Yes, in one case.
In one case, they
My affirm.
But in the other case, the writ court must not be satisfied with the order of the tribunal.
No, writ court direct disposal of matter. Because of the no counter file in that case. In those no counter file. Therefore, on this one they directed in 2019. You may approach the tribunal. You may approach tribunal. Thereafter, my lord, and page 16 2022. Subsequently, the writ petition was not challenged. Subsequent file that was dismissed. 2019, my order passed.
I'll also have to put this, put on my mind. Because of your pitch.
Sorry, madam.
No, why are you in a hurry? We are not in a hurry.
No, I am also not in a hurry.
We are going slow. We are just understanding the positions.
All right. Now, let us understand which order of the tribunal was affirmed by this court.
That was, my lord, that order, my lord. That is, my lord. Page 69, my lord, that is, my lord, operating set. OA number, my lord, sorry. OA number 2474/11.
OA number?
2474. C bet 11. Basanti Lata Mishra.
This, when was the order passed?
That was passed in 2022. That order passed, my lord, on 4/2022.
22?
My lord.
In OA?
No, read in OA order passed on, my lord, 28/9/2015.
And when was the writ petition dismissed?
Writ was dismissed on, my lord, 4/2022.
Four 2022.
My lord, plus 89.
How many writ petitions?
One writ petition.
One writ petition. But before that, the liberty was granted by the High Court to file review before 2022.
This order was also produced before the Honorable Division Bench, but Honorable Division decided that as because similar matter has been confirmed by Appeals Court, so writ was dismissed. In similar matters, all writs were dismissed, confirmed by Appeals Court, or the resource teacher case, my lord. My lord.
Sorry.
My lord.
Mr. Manti,
My lord.
you make a compilation of orders.
That I given on my note, my lord. Why? Flag Y, my lord. At the very beginning, I said flag Y, I have given the dates, my lord. All the dates are given. My lord.
Give us. Give us, we will prepare ourselves.
And flag Y, my lord. I already given. There's already mentioned.
See,
Flag Y.
Two sets of cases.
My lord.
One, you say it is confirmed, no review.
No review.
Confirmed.
Not so.
Supreme. The other part came here, but directed for filing review. So those two cases, in whose cases they were there, and what are the orders or judgments passed, to make a compilation so that it will be better understood by us. You might have conducted cases before the tribunal here and before the Supreme Court. You are well acquainted with the entire gamut
of the case.
So to make us understand, let us have those side by side. So that we can.
I will start from beginning. 2000.
No, we don't have that much of questions. Let us and we will understand. We will go back in our chamber, so we will see.
No, my lord, the note of submission, in the note of submission, all the
We assure you, we will see your notes also, note of submission.
And the note of submission, I have decided.
Please.
Let's have another date. If it
all right.
My lord, that's a fixed date, man. We'll have to prepare after.
Friday.
ଆପଣ ପ୍ରିପେୟାର କରି ଦେଇ ଦଉନାହାନ୍ତି ଗୋଟେ ଦିଟା ସେଟ୍ କରିକି ଦେଇ ଦିଅନ୍ତୁ ଖାଲି compilation of orders.
Undisputed facts, cases, orders, where it went to Supreme Court, where my lord's directed, I will make it and I will give it. My lord may give me 10 days time and do it because
2 weeks. Right.
In the connected case also I am there. In the connected case, I am also there.
We will see.
I will also file a compilation. Because number of cases were filed, and in number of cases, the matter went to the Honorable Apex Court, and the Honorable Apex Court confirmed the said. And those judgments were implemented by the state. Now, so far as the
we want two
review petitioners are concerned.
Sets of cases.
Yes, compilation.
What is the process it took?
Yes.
Till it reached the culmination.
All those papers are necessary. Yes.
Item number 18.
it will be 2 weeks time.
Yes. 2 weeks.
18, my lord.
18, my lord, pursuant to my lord's orders, we have deposited the cost, my lord, and we have filed.
We have received
and I will serve copy.
We received the money amount. Yesterday we have received the amount, my lord, and we'll just receive the counter.
If counter is available in my lord's slip because it was refiled. So,
Noting it has been mentioned that it's not filed.
no, it is filed. My lord, may kindly direct the registry, we have filed.
It is stated by learned AGA that a counter affidavit has been filed in the registry on
My lord, yesterday.
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 the problem is this case, and they said counter affidavit is not there on record. List this matter on 2 weeks with the said counter affidavit on record.
Item 19.
And my lord, we have complied with my lord's order of cost.
Oh, no, that's correct.
Yes.
Item 19.
Your Lordship, On behalf of Vijay Bibu Prasad Tripathi appearing for OP number 2 Orera, I pray this matter be taken up on Thursday as he's on his legs in court number 3.
Actually, it's a non-adversarial litigation. The orders of the Orera is not being executed by the Orera itself, and it is acting like a post office and sending it to the civil courts. Whereas the statute requires otherwise, requires the Orera to execute its order. So since the year 2017, not a single order has been executed, Your Lordship. So the litigants are facing problem.
He is seeking adjournment, right, as requested on behalf of the petitioner lists this matter on 2 weeks. A petitioner, respondent, opposite party.
Opposite party too.
Item number 20.
Item number 20, I am for the petitioner Miller. In obedience to your lordship's order dated 22/2024, I have already implemented the Gram Panchayat as party Miller, and I filed the amendment petition. Simultaneously, I filed one consolidated cost title of the writ petition Miller. And as per your lordship's direction, the state has not filed any counter.
Was by the order dated 20th of February, lordships were in a detailed order, not a director to file and consolidate affidavit regarding towards the state laws. What are the methods laws? I need some more time because they are compiling the everything. 2 weeks time, lordship may grant. In the meantime, I can file it affidavit.
Which was the order?
There's a lordship's order dated 20th of February 2024.
Light posts. Light posts.
Yeah. Order number 10, your lordship may look at.
What this order was passed when?
Paragraph 6 and 7 of the lordship's order.
This order was passed on 20th of
February.
February. How much time do you need?
Only 2 weeks time, your lordship may grant. In the meantime,
By way of last indulgence, 2 weeks further time is allowed for the state to comply with the order dated 20/2024. Stop, list this matter on 2 weeks.
Item 21.
So direct, I will file the requisite for issuing notice.
Why notice?
No, he will file because he newly added party the Gram Panchayat against him. Who will saying?
I will file.
He will file the requisite for issuance of notice. Not so.
Have you filed consolidated cost title?
Yes.
Fine. You're not there. When did you file?
As your lordship direct.
When did you file your consolidated cost title?
That is dated 28/2/2024.
What's your record? Consolidated cost title. That's it.
No, it's not tagged. Not even tagged to this record.
20.
February, 28th February.
Next, on the next date, we will consider. That aspect we will consider on the next day. Let the affidavit come first.
Item 21.
Lord, I'll just request my lords to see order dated 20th of February 2024.
Yes.
Passed by my lords.
Lordships
And
were pleased to
this
grant.
relates back to the order dated 24th of April 2023. 21/22, my lord, they have taken deposit from me. From their side, they stopped me from operating it, saying that joint verification, the canal stream and embankment will be in danger. The state themselves stopped me. Keeping that in joint verification, this honorable court on 24/4/23 directed them to refund me back because they themselves did not allow me to operate it. And your lordship also considering that on 20th of February directed them to refund me within 1 month there, 4 weeks thereafter. Till date, they have not refunded.
Yes, in fact, Tahsildar has initiated the proceeding because he doesn't have the funds, Lords. He has now requested the collector to place the funds on pay email. I've talked to him, Lords. He has already written some more time is required to pay. We will pay it back.
Tomorrow?
Ah.
Tomorrow at 4?
2 days time, Lords. Because
Today, 3 o'clock.
2 days time, Lords can.
No, this order was passed on
Yes,
20th of February.
No, because
so either you are somewhere deficient or you are not respecting the court's order.
No,
so these are the only.
No, the Tahsildar doesn't have the funds. Once it is kept in emails, it goes to the emails consolidated fund of the state government. Now he requested the higher authorities to place the funds with him for refunding the OP number 6 emails.
Yes.
Of course, in the process, 1 month was sufficient time, Lords.
Tomorrow at 4.
Yes, no.
Samantra, for OGFR,
No.
certain limits are given.
Right, ma'am.
Right?
Yes.
You're going to say that.
Yes.
But for court's order to be complied, is it required for getting?
No, he is not following OGFR, Lords. Because he doesn't have funds with him at the Tahsil office, Lords, because the amount is deposited to Tahsil. He writes to the higher authority to place the funds at him through treasury, Lords. He has to make an advisory to the treasury and through treasury.
He doesn't have the funds.
Yes.
Don't pay.
Yes, no, sir.
Item 22.
My lord, item 22, I know, my lord, I have taken time twice. Still, I was getting ready in matters, item number 17, my lord, so 22. My lord, kindly accommodate me one.
The time was taken more than 4 times.
My lord, I have.
Actually, it's rare appeal, my lord. I'm suffering, my lord, because I am out of employment, my lord. I leave it to lordship.
I will, my lord, tomorrow.
Tomorrow. He can also given. Not he is client. So he must be charging every day fee.
Tomorrow.
He is happy.
I am not charging female in that way.
Tomorrow I am ready. Actually, my lord, I wanted to say because from Wednesday, Thursday, Friday, I am going out.
Tomorrow we can take.
Tomorrow I won't be here. For 3 days I am not there.
Then if he gives you consent, then only. Otherwise,
I will be,
both of you are friends.
I will be in a fix. Well, I will be in a fix. I leave it to lordship.
27th, 27th, I assure this one.
No, April 2nd.
You're staying 27, my lord. 27 at 2 p.m.
I assure this one.
Many matters are there. On 27, 28, we have many matters. Again, the same prayer.
We can become the matter in the month of April.
Well,
Right.
Well.
We can fix a time.
at 2 o'clock, my lord.
Is it a wrong matter?
Yes, my lord.
Then we will take up at 2.
Well,
9th of April.
well.
Oh, bless.
Yes.
Item 23.
May I please, lords? Lord, here the grievance is, my lord, against the order of the Honorable Single Judge. Annexure 4 starts from page 28. It's similar, it's a matter relating to appointment of Anganwadi worker. And she has been continuing, my lord, from 2006, by now 16 years, my lord. And if lordship look at page 31, the order starts of the Honorable Single Judge. What has happened, my lord, if you also look at page 33, para 7. Earlier, my lord, in the earlier round of litigation, we own in the appeal filed by the other side. And in the second round of litigation, my lord, kindly come to para 7.
No, this is the order which you are challenging.
Yes, ma'am. Annexure 4.
Yes. Yes.
You also can come to page 33, para 7. The Honorable Single Judge, my lord, just quoted, my lord, the order passed by the ADM in extenso, my lord. The entire order was quoted. And my lord, in the last paragraph, page 38.
Yes. So what is wrong?
Wrong, my lord, if you also look at page 37. The wrong committed by the ADM. The ADM, my lord, has not referred to its earlier order and indicated, my lord, one word, my lord, if you also look at second paragraph, page 37. I will show you also, my lord, the advertisement, the area where, my lord, I should have been as a resident. Having heard both the parties to the dispute and going to the evidence on record, I am of the opinion that the college road extends from Raghunath Samavaya Mahavidyalaya, Oregon to police station, Oregon. The residences located in either side of the aforesaid road are called the residence of College Road. Different sahis have originated from College Road and extended in different directions away from the College Road. It is seen that between Gauda Sahi and Nityananda Sahi, there is another Sahi called Gupta Martha Sahi. So Nityananda Sahi is neither close to Gauda Sahi nor within the College Road. The residence of respondent number 5 is in Nityananda Sahi, which does not come on the service area of Dalak, Gha Anganwadi Working Center. Relating to the report of Tahsildar Oregon addressed to the sub-collector Nayagarh, one can clearly come to a conclusion. The respondent number 5 is not the residence of Dalak Gha Anganwadi Working Center area. In the result, the prayer of appellant is accepted. Engagement of respondent number 5 as the Anganwadi worker, Dalak Gha AWC is set aside. The matter is remitted to the selection committee to distribute the matter after keeping in mind the findings of the respondent number 5. Finding that respondent 5 was not a residence of Dalak AWC area at the time of our selection as AWW. The report of RI Oregon at the backside of this case is neither acceptable.
The authority has reached a conclusion that you are not a resident of that area.
My lord, can you see the same appellate authority in the prior allegation, my lord, made by the respondent number 5? What was the report, my lord? If you also look at the first order, that was passed, my lord, annexure 2, page 22. Same Rasmani Dora, my lord, has filed that appeal. 2 appeals, my lord. Anganwadi appeal number 14 of 11 and 15 of 11.
What is your name?
My name is, my lord, Ranjita Naik.
Ranjita Naik.
Yes, ma'am.
There is some other
Naik.
What is the finding in this order?
But in the finding, my lord, if you also look at page 22.
Your respondent number 5 there.
Yes, ma'am.
Rashmi Rani Dora was the appellant there.
Yes, ma'am.
In appeal number 14 and 15 of 2011.
Yes, ma'am. And my lord, the finding is page 24. Having heard both the parties to the dispute and going through the evidence on record, I am of opinion that College Road extends from Raghunath Sambai Mahavidyalaya, Oregon to Police Station, Oregon. The residents located on either side of the aforesaid road are called residents of College Road. Different sides have originated from College Road are extended in different directions away from the College Road. It is seen that between Gaud Sahi and Nityan Sahi, there is another Sahi called Guptamata Sahi. So Nityan Sahi is neither close to outside nor within the college road. The residence of respondent 5 is in Nityan Sahi, which does not come under the service area of Dhalak Gaon, relating to the report of Tahsildar Urga addressed to Sub-Collector Nayagarh, can only clearly come to the conclusion that respondent 5 is not the residence of Dhalak Gaon AWC area. As a result, prayer of appellant is accepted, engagement of respondent 5 is set aside, matter is remitted to the selection committee to dispose the matter afresh, keeping in mind the findings of respondent 5 is not a residence of Dhalak Gaon area at the time of our selection at AWW. The report of RI Orga at the backside of certificate is neither acceptable nor reliable on the ground that mis certificate is prepared and issued on the basis of the report submitted by RI. Here, counter affidavit matter, page 26.
Annexure 1, Annexure 1, page 50. Page 15,
I'm extremely sorry, the first order was annexure 1. First order was annexure 1.
Here in this appeal,
15 of 2011.
You were respondent number 5.
Yes.
Your claim was not accepted here.
No, my claim was, her claim was not accepted.
You were not the resident of
that was the subsequent. Yes, that is the second round.
AWC.
Yes, that is the second round. The first round, madam, I'm sorry, but I could not show you also. Page 17. It's annexure 1.
In this appeal,
yes,
you were found that you are not the resident of the.
No, in the first round, madam.
Please, sir.
Madam.
The portion which you have read,
madam,
what we understood,
madam,
that in this it is found that you are not the resident of
that area. Yes.
Area Dalak Gha, Anganwadi Center. Area. Right? That is in appeal 2011. Appeal number 2014 and 15 of 2011. Filed by the other side. And you were it is against you.
But the first round was in my favor, my lord.
This was dated.
This was dated
4/1/17. 4/1/17.
My lord, 4/1/17.
Additional District Magistrate Nayagarh.
My lord. But the first round, my lord, it is annexure 1.
No, it is not 4/1/17. It is 11th day of January. 11/1/2017. This is annexure 2.
Yes, that is annexure 2. But first round, my lord, whatever I have read, my lord, the first instance, my lord, was the order quoted by my lord, Honorable Justice Paniresh. My lord, the first round is annexure 1. In the first round, my lord, that is AW appeal number 15 of 2011.
21st February 2012.
Yes. Yes, madam.
Additional District Magistrate.
Yes, madam. That passed that order.
Nayagarh.
Madam.
Has passed the order in AW appeal number 15 of 2011.
Madam. And the observation, my lord, page 17. And in that appeal, my lord, I was respondent number 7. The appellant Sandhya Mishra and respondent number 7 Ranjita Nayak were applied for Anganwadi and Anganwadi worker Dalak 4 AW Center under Odoga ICDS project in response to advertisement dated 16/9/2011 and Dalak Gha comprises of Dalak outside and College Road. It is admitted fact that the appellant Sandhya Mishra awarded 67% of marks and respondent Ranjita Nayak awarded 56.46% marks. The appellant filed residence certificate of village Dalak from Tahsildar Odoga. White revenue miss certificate number 665 of 2011.
In para 4, Ranjita Naik, that is you who was RI reported. Revenue inspector has given a report saying that you belong to village Dalak,
yes,
College Road, which is within Dalak Gha
AWC area.
Center area.
Yes.
You are relying on that.
Yes, ma'am. And if I
by this finding, was the appellate authority bound by this finding? Because the appellate authority said that RI report is incorrect this order was passed based on the report of the RI. So our question is whether the appellate authority, the subsequent order passed in 2017 was bound by the order which he had passed in 2012.
Bound to the extent, my lord. I don't dispute that, my lord. But to the extent, my lord, when there is a direction for rehearing, then he has to see what was the advertisement for, what was the area in the advertisement. He cannot be permitted to twist, saying that this bill has come to that side, that bill has come to this side, so it is not within that area. If you also look at the advertisement, in terms of the revised guideline of government, my lord, relating to appointment of Anganwadi worker, it was indicated on the advertisement, Dallag Gha area. If you also look at the advertisement for a minute. And the counter measure in the first litigation, in the second, in the impugned order which was passed, in the counter affidavit matter, the government accepted my case.
We are Anganwadi Tribunal.
I'm not saying that. But my lord, yeah, this is the only forum, my lord, available.
Yes.
This is the only, after the appeal, my lord, it is only for your lordship, my lord, to consider. And I have been working, my lord, for 16 years.
Someone has filed caveat.
Someone has appeared. Already.
You have.
And in the meantime, he has been disengaged. After the order of this single judge, he has been disengaged. The appellant has been disengaged.
Oh, that has been stayed by the
No, no, no.
not stayed.
Well,
It is from my lords to see, but I have said the order is there.
Your lordship.
And they are not accepting this, I filed a miscase, which on the last occasion, your lordship,
Your
I have
lordship
indicated to lordship to take up that idea.
25/9/2023. Prior to that, she was disengaged. She was disengaged on 8/9/2023.
Well, can you see the language in the order? In the meanwhile, the status quo so far as the handing over of the charge in respect of Anganwadi center in question shall be maintained.
So
Because
prior to what Mr. Kutia says,
well,
by the time 25th September 2023 order came to be passed by this court, your client has already been.
No, I had indicated. I have indicated that that document. That's why, my lord, this order was passed in that manner. That handing over is subject to status with respect to handing over.
But termination was.
And so as caveat is concerned, my lord, he has. Rejoinder is your flag F. I have given the original copy as well as the translated copy. Flag F, rejoinder, my lord, page 8. My lord, Justice Samad Putsi, my lord. Serial number 18, Dallag Gaudasahi, College Road. And my lord, page 13, my lord, the English translated copy. Dallag, page 13, my lord. Dallag Gaudasahi, College Road.
All right, we will see.
I am for the opposite by 6, my lord. 2011, there was a finding by the. My lord. Only one thing, that the ADM in the second round inserted the word service area. So
Item 24.
Mr. Mahanti, you are for the opinion.
Any other data?
No, orders will be passed. Judgment is
Vijay.
I have not submitted it.
Hang on, please.
We will submit from your place.
I only want to review to a judgment of additional court. Person, my order of additional court.
Where my lord, Honorable Single Judge has dismissed the writ petition on the ground that there is an appeal provision under the National Green Tribunal Act. Yesterday, your lordship has put me two specific questions. First, with regard to maintainability of the writ petition. Second, my lords, whether the same issue before the Honorable Single Judge could be adjudicated by your lordship in a letter patent, my lords. My lords, before addressing your lordship's question, also I have done the research so far as maintainability. There are judgments of High Courts and Honorable Apex Court where, my lords, appeal provision cannot take away your lordship's jurisdiction under 226 and 227.
Counsel, the question is
Yes, my lords.
that when the appeal lies before a superior court,
Yes, my lords.
whether the writ petition should be entertained by this court or not.
Exactly, my lord. My lord, that question also I'll submit, my lord.
Before my learned friend starts, may I assist one thing to your lordship? Similar matter, similar order, same honorable judge, single judge.
My
One
lord.
writ appeal was entertained by this honorable court, which is pending, and my lord Justice Raman is a party to that. An exhaustive interim order was passed in writ appeal number 2282 or 2023. Jugal Kishore Mishra and State of Orissa and
I
others,
have the
in which senior advocate entered appearance for the petitioner, argued the matter, and your lordship has passed the interim order admitting the appeal and issuing notice, and the matter is pending. Similar case, whether in view of the appellate provision, provision to file appeal before the Honorable Apex Court, the writ appeal is maintainable or writ petition is maintainable.
My lords, in that,
Can it be had along with that if so? Same order.
That is interim.
Interim order is passed. An exhaustive interim order is passed. Taking into consideration the decisions of Madhya Pradesh High Court Bar Association versus Union of India and other case laws. Same order and same honorable single judge.
Yes, with decision, you are relying on.
yes, my lords. My lord, this is what I was supposed to present, my lords. I'm thankful to my learned senior. Second, my lords, I place your lordship's
Cite one decision
yes, my lords.
where the Supreme Court says
Yes,
that the High Court can should entertain.
Yes, ma'am.
a petition
yes, my lords.
where the appeal lies to Supreme Court.
Yes, my lords. My lords, Madhya Pradesh High Court Bar Association versus Union of India. My lords, I have the copy, my lords.
That is noted in that order.
Yes, my lords.
Paragraph 4.4.
Yes, my lords. My lords. Yes, my lords. Para 8, then my lords, lordship may kindly have a glance at page 18 of the judgment, my lords. Pagination is at the bottom, my lords. May I place, my lords?
Originated, sir.
My lords, because of the printing issue, that last page is missing, my lords. Page numbers have been.
Originated.
I'm sorry, my lords. After getting the printout, I could find that.
Which paragraph you are doing?
My lords, para 8, my lords.
Very difficult to find.
I'm sorry, my lord.
Paragraph 5, paragraph 7, and then paragraph 25.
बाहर कर दो.
My lord, sir.
Yes, place it.
Yes, ma'am. Explaining the purpose to constitute a specialized court to deal with the environmental issues in the Mantri Technozone Private Limited versus Forward Foundation, 2019-18 SEC, page 494. Justice S. Abdul Nazir, writing for the three-judge bench, made the following pertinent observation on the statute of NGT. The tribunal has been established under the constitutional mandate provided in Schedule 7, List 1, Entry 13 of the Constitution of India to implement the decision taken at the United Nations Conference on Environment and Development. The tribunal is a specialized judicial body for effective and expeditious disposal of the cases relating to environmental protection and conversion of forest and other natural resources, including enforcement of any legal rights relating to environment. The right to health environment has been construed as a part of the right to life under Article 21 by way of judicial pronouncement. Therefore, tribunal has special jurisdiction for enforcement of environmental rights. May I pray, Lordship, para 9 and para 10 may be skipped. The issue discussion is at para 11 may be read, my lords, in the last line, my lords. May I place it, my lords?
Yes.
With issue-wise discussion. Issue number A, whether the NGT outs the High Court's jurisdiction under
Position with this, there is no dichotomy. We are not saying that High Court has no jurisdiction under 226.
Yes, my lords.
We are asking under, we are in the writ appeal.
Yes, ma'am.
Right?
Yes, madam.
Can we test that order where the single judge has held otherwise, saying that there is alternative remedies
My lords.
available for you. He has not entertained.
My lords.
So that is the question, perhaps.
And not only that,
My lords.
this decision
Yes.
of Supreme Court refers to L. Chandra Kumar.
Yes, my lords. I have. Yes.
Do you know the history of L. Chandra Kumar?
Unless I have read the judgment.
What? The history of
My-
L. Chandra.
History, my lords.
L. Chandra Kumar was a judgment
Yes, ma'am.
which had arisen from Andhra Pradesh.
Yes, ma'am.
All right.
Yes.
There was Sampat Kumar decision before that,
Well,
where the court had held that the only High Court will does not have it.
yes, ma'am. Appeal to Supreme Court.
Andhra Pradesh High Court held that the decision of Sampat Kumar is per incurium
Yes.
because it had not taken note of the concept of basic structure of the constitution.
Yes.
Andhra Pradesh High Court for the first time ruled that Article 226 is the basic structure of the constitution, which was not taken into account in the case of.
My.
Okay, therefore, the Andhra Pradesh High Court was of the view that Sampat Kumar with per incurium and the High Court had.
Yes.
The matter traveled to Supreme Court.
Yes.
The Supreme Court observed that the High Court could not have held Sampat Kumar's case per incurium because the High Court does not have should not hold any decision of Supreme Court per incurium.
Yes.
Still, the Supreme Court, following the observations, you can say, made by the Andhra Pradesh High Court, held that 220, Article 220, that is for the first time that the Supreme Court said that Article 226 is basic structure of the Constitution.
My.
That is judicial.
Yes, ma'am.
It is in that background that it has been referred to. The question still is
Yes.
where the appeal lies to Supreme Court.
Yes.
Now, can you challenge the power which the Supreme Court will exercise under Section 22?
Yes.
Of which nature?
Appellate on the appellate.
Statutory.
Yes, statutory. Yes, ma'am.
And we have constitutional power under Article 226.
Yes, ma'am.
So we shall entertain judicial review of the order passed by the Supreme Court? Should we?
Well, it's subject to the provided the appeal is taken to Supreme Court.
Question is, we will know that when Superior Court is the appellate authority,
Yes,
the High Court should not entertain writ petition.
My lords, with greatest respect, my lord, this is a different angle, your lordship. I bow down, my lord. This is a separate question. Let this question, whatever lordship says, I bow down, my lords. I may be, let's the subsequent paragraphs, my lords. Section 22 of NGT Act also been dealt with. Probably their lordships would have kept in mind that the appeal under 22, section 22 is is before the Supreme Court, then also the writ petition has been entertained.
Supreme Court says that the power of judicial review cannot be ousted.
Yes, madam.
This is what was laid down in Chandra Kumar that
Yes.
has been
Yes.
reiterated in this decision also.
Yes, madam.
Whether there is any finding
Yes.
that despite section 22, the High
Yes.
Court should entertain a writ petition, and that will have a very serious consequences. If the High Court starts entertaining writ petitions,
My
then
lord.
the High Court may, the argument can bet that the power of the Supreme Court was exercised under section 22, that is statutory power. You have the constitutional power under section 226 of judicial review, that is not ousted, therefore entertained. Therefore, the hierarchy of the courts, that will have to be taken into account.
My lords, I bow down, my lords.
That will be-
My lord.
We will decide it.
My lord, may I submit one thing, your lordship? Your lordship may keep it to tomorrow along with this, because same nature of case, Mr. Palit is appearing for the petitioner. It can be hard, and because that.
My lords, two other judgments where my lords, my lords, my place, my lords. There were two other judgments, my lords, where the same issue. Or lordship may allow me. Well, this is the same. My lords, in Allahabad High Court also, my lords.
Yes.
Yes, ma'am. That's para 25 minutes.
File is not there in the.
Yes.
Hotel Star, Hotel Grand, you'll see.
Yes, my lords.
Yes, there is no paragraph.
My lords, quote, I mean, it starts with para, in para 9, para 25 has been quoted, my lords. That's para 9.
No, that 55 is
Yes,
coming
madam.
from Magad
Yes, my lords, yes. It's in para 9, next page, para 25, it starts with. Yes.
That's all.
That we are not.
Lordship, I'm just placing, because my lords, the conditions that has been a violation of principle of natural justice. My lords, I am digressing from law to facts, my lords, because my lord, here is a question where I have not been heard, my lords. That may, my lordship may kindly note that. I bow down, my lords. That question, I mean.
Even you see, where there is violation of natural justice, unless it is Caesar to Caesar wife. Natural justice.
Yes.
Unless it is Caesar to Caesar wife.
Yes.
The question of natural justice can also be gone into by appellate.
Indeed, my lords. Indeed.
Then, provided the appellate authority, it will be a futile exercise.
Yes, ma'am.
So here, you are not doing any futile exercise, rather you are going higher up.
Yes, ma'am. Malas, then this question leads me to
Even Whirlpool or
counsel is that unless
yes, ma'am.
we hold something, the law will not be clearly laid down.
Malas, we all would be highly obliged if this settled. This is settled, my lord.
That is why I was submitting. Since your lordship is going to lay down a law, so this matter can be heard, and he is the senior advocate is appearing for the petitioner. He can assist to your lordship that case law, that order which I have given. My lord is a party to that.
Tomorrow the matter is coming.
No. Your lordship may call it tomorrow along with this.
now my lord is of the opinion that since that is interim order.
No, that is pending.
So-
that is what
so in any
I
other
want to
case-
bring it to your lordship.
In
notice.
any other case, when the matter is taken up and heard, then there is nothing wrong in passing the final.
And
That is-
that will be done for better assistance of the honorable court.
Better assistance we can have from the advocate general. Better assistance we can have from any senior counsel available.
That is why in that case, Mr. Palit was appearing for the.
No.
Yes.
My lord, sir.
No, if he wants to argue, you can argue in this case.
So.
If he wants, he can argue.
My lord, sir. May I just bless the Madhya Pradesh High Court's judgment? I'm sorry, my lords, if I request your lordship to have once again Madhya Pradesh Bar Association judgment, where my lord, there is a clear finding on section 14 and 22 of NGT Act. As in consequence of the above analysis, our conclusions are the National Green Tribunal under section 14 and 22 of the NGT Act does not out the High Court's jurisdiction under 226 and 227. And the same is a part of the basic structure. The lordship, what has fallen from your lordship, that has also been mentioned. And so far as if I may submit, my lords. So the second line of argument was before in the said case, my lords, that because of the constitution of the benches of National Green Tribunal in other states, and then to Supreme Court, considering the economic consequences and the burden on the parties, and coupled with the fact that the parties are not being heard by the National Green Tribunal benches constituted outside the state.
Therefore, we are putting this question.
Yes, ma'am.
Should any order passed in the Act
Yes, ma'am.
be challenged before the High Court?
Sorry, I'm sorry, ma'am.
Is there any order passed under the Act?
Yes, ma'am.
Irrespective of the authority?
Yes, ma'am.
Can be challenged before the High Court in the 226?
Provided, I bow down, my lords, provided there is a violation of principle of natural justice, then your lordship. Yes, my lord.
You can arrest.
My lords, absolutely correct, my lords. My humble submission is, my lords, because there is a economic consequences and the bench.
See, when you cited this Allahabad,
Yes, yes.
we are not disputing also this fact.
Mine.
You see, undisputedly, section 22 of the NGT Act provides for an appeal to apex court against the order passed by the tribunal.
Mine.
There is no dispute.
Yes.
The apex court in such and such case has clearly laid down that the power of judicial review of the High Court
Yes.
under Article 226 and 227 of the Constitution of India is not ousted by Section 22 of the NGT Act remains unaffected.
Yes.
That is also we are not disputing.
Yes, ma'am.
Right?
Yes, ma'am.
So we are on the question that in spite of all this, unless the appellate remedy is a futile exercise that you demonstrate, right?
Yes, yes, ma'am.
So why should not we relegate
Yes.
you for availing the alternative remedy, particularly when the learned single judge has not committed any error apparent on the face of the record, on the face of this.
My lord.
Mr. Palit has come. Let us. Keep us here. You are arguing a matter.
NGT order.
Yeah, I'd relied upon that Madhya Pradesh
Yes.
Bar Association's case.
The question is, when the Supreme Court is the appellate authority, whether the High Court should exercise power or judicial review or not. Generally, yes, there is no quarrel over the principle that is not ousted.
Whirlpools.
The larger the question that the power of judicial review is basic structure of the Constitution. That is also not in this. But the question is, when we lie to Supreme Court,
22.
then
I was given to understand by my friends there, my lords. Probably the Honorable Apex Court felt that too many matters were going there directly. So therefore, that was probably the underlying logic.
Mr. Palit,
My lords.
if you can assist us with service tax matter for a classification of entries after such order, High Court is not in session. It is to the Supreme Court direct. So there we cannot say that classification of entries can also be domain of which emanates from assessment orders. So their direct provision is there. In service tax matter, excise matters
I'm
also.
not aware of the facts of this, my learned friend.
A similar fact.
Similar case. Similar.
It is emanating from NGT.
An order of the tribunal, he wants to say that the on the ground of violation of principles of.
What we are of the view that unless it is seizure to seizure wide or appellate remedy is futile, the natural part of natural justice can also be gone into by the appellate authority or appellate force.
Beyond doubt, Manoj, beyond doubt, it can be.
So
But
even
that's-
a Whirlpool, after that, Radhakrishna also.
Manoj, Whirlpool and that those line of judgments are there.
Even trend of the orders passed or judgments
right,
passed by
that's
the
Or
even
if the Supreme Court laid down law, as was laid down in case of L. Kumar, that yes, these matters can be.
This is not a, Madhya Pradesh may not be in the line as strong as L. Chandra Kumar.
Exactly.
But it gives an avenue, Manoj, that it can either in the High Court or even in the Supreme Court. It gives it is selective. It's a kind of a selective remedy that has been fashioned by the Honorable Supreme Court in this one.
So this is what we intend to hold. One, that we do not find any illegality in the order which has been passed by the current civil for us to interfere in an intra-court appeal. Two, when the question arises of exercise of judicial review, when the appellate power rests in a superior court, then the court should not exercise the power of judicial.
Even on the teeth of violation of principles of natural, Whirlpool principles.
Feel like yes, because therefore, the
Just to assist your lordship, Manoj, I may not be taken out of context or may not be taken amiss.
To place a small note, my lord, because there are two other judgments where so that lordship can.
You can do that.
Yes.
Before
I'm obliged.
before your lordship takes up this matter, 25, my lord, I want to beg apologies, my lord, for filing a counter in an appeal to which my friend has filed a rejoinder, my lord. That was because on 4th of December 2023, my lord, I wanted to bring a certain document by way of an affidavit and eventually filed counter affidavit, my lord, which should not have been, I should not have done.
In writ appeal, so many pleadings.
Yes, my lord, I know, my lord, my lord, that is the reason your lordship I leave it to your lordship, my lord, to ignore the counter.
In fact, when yesterday I made a submission of your lordship that because of my learned friend has filed a counter, I am presenting a rejoinder, which copy of which was served on 5th of this month. Your lordship was pleased to observe that your lordship will ignore the counter as well as rejoinder is
No,
not there.
we were of the view that writ appeal is to be decided on the basis of the material which were there before the learned single judge. If certain materials required for proper adjudication of the case were not there before the learned single judge, then you could have filed a review instead of filing appeal.
But here is a case where, in fact, the writ petition has been disposed of without hearing the present appellant, though it was brought to the notice of the Honorable Court that by the time the final adjudication was made, I had already been granted with a temporary permit. Now, it is with regard
Just a minute, where is the order?
The impugned order is at page 34. Your lordship will kindly peruse. May I with your lordship's
Yes, which part of the order affects you adversely?
my lord, what has happened? My temporary permit was granted. Now his case was rejected. Now the Honorable Court has been pleased to direct that it should be revisited afresh. Thereby, my permit goes, my lord. And this was
Revisiting is different.
Total reconsideration and the process.
Had your license been cancelled, the matter would have been different.
What has happened? What happens? Let me just explain. When the operators they apply for the state carriage permit, the newest vehicle is given preference. Now here, by the time the cut-off date was there, his vehicle was not ready, not yet registered. He sought for little time. 5 days time was granted that window. He got it registered on 3rd, though first was the cut-off date, and it was extended up to 5th. Now after he applied, under the provisions of the Motor Vehicle Act, the route is the paramount consideration.
So the routes have been fixed and the timing is fixed. Now he applies for a defective route by including Deoghar, which is not part of slot number 110. Slot number 110 is dispute, so far as this dispute is concerned. Slot number 2 is downstrip and that is offstrip. Slot number 110 is under dispute. Now, when he applied for a defective route, that got rejected. There is a provision for appeal under section 89 of the Motor Vehicle Act against that order. He doesn't challenge it in appeal. He comes directly to this honorable court, and by the time the case was taken off, the honorable single judge, what is affecting me is, honorable single judge says these are formal defects, so this should be rectified and reconsidered. That is where my grievance is. But it's not a question of rectification. If your lordship will look at the statute, it says you should specify the route, and the routes are defined already.
Whether before this order was passed, you were already granted the.
I was granted temporary permit. In the meanwhile, my permit has been made permanent. This was also brought to the notice of the honorable single judge in paragraph 5. Now he files a petition for amendment to include the grant of permit in my favor and quashment of the same. But he didn't file a petition to implement me as a party. Your lordship will see the writ petition copy has come before your lordship. There is a IA that was filed, IA number. Your lordship will see the writ petition. IA number 14188 of 2023 was filed for amending the writ petition to incorporate the fact of a grant of permit in my favor and for quashment of the same.
No, please come to paragraph 5.
Right.
Learned counsel for the petitioner, however, submits that temporary permit was granted to another operator. This is you.
Much obliged. And he files a petition for amendment to pray for quashment of the permit that has been granted in my favor, but he never prayed for impletion of me as a party. Now the court says the defect is formal, you reconsider by allowing rectification of defect.
He should be right in his submission.
I should be heard.
He should have been heard.
My lord, may I just bring it to your lordship notice relevant facts, my lord.
No, where is the question of C? Come to paragraph 5.
5, my lord.
This was your submission.
No, not my,
This was
yes, my, lord, that's my submission.
This was
But
your.
your lordship may kindly note the dates, my lord. On 29/8, my lord, 29/8/2023, the honorable single judge took cognizance of my grievance and directed the standing counsel transport to obtain instructions, my lord, without granting any interim order to me, my lord. Then, my lord, the matter was again placed before the, and the last chance was given. Thereafter, the matter was disposed of. And in the meantime, my lord, this temporary permit granted to.
So he should have been pleaded.
My lord, that is the reason your lordship may kindly see the honorable single judge has taken that aspect into the matter, and it's an open remand. Your lordship rightly asked the question, how you are affected. My lord, his service has not been affected. His permanent permit has not been stopped. His vehicle is not stopping, nothing, my lord, excepting that matter has to be revisited because of the reason, my lord. I have offered a brand new vehicle and
possibly in his presence, the order would not have been passed. We don't know.
No, my lord, the would not have been much difference because, my lord, because ultimately, my lord, what has happened, my lord, the ineligible appellant has been selected in place of eligible, my lord.
And then you, instead of filing this writ appeal, you could have filed review or recall or application.
Why I filed, my lord, before lordship, the case, my lord, I could have filed there also. My lord, I have appealed the remedy of appeal. That's for the reason, my lord, here is a case where they served a notice for rehearing. So in the process, my lord, I would have been dislodged. Now I have a permanent permit in place. Now the thing my friend is pointing out, let me just clarify. Why he is saying it's an open remand and there is nothing affected.
No question of open remand. The question only is of the fact that you were not impleaded as party and in your absence, the order was passed. So now you have filed appeal. The Supreme Court says that in such circumstance, you could have filed a writ petition or an application for recall.
I have nothing to dispute about that proposition. I have nothing to dispute. I cannot possibly dispute that proposition of law. But I have come up in appeal and your lordship is seeing the order. So that is the position. And if your lordship relegates also, in that event, I may be protected because I have been protected here. I have been protected by this noble court. Now I have a permanent permit in place.
All right.
And that will be the position.
One more thing, my lord. Subject to your lordship's acceptance, my lord. And after this order of the honorable single judge, my lord, the estate took cognizance of the matter and notice was issued to all the concerned. All the
All right, he has the this option to withdraw. He's doing that.
He can face the competition. What is happening, he doesn't want to fair competition. That is my case, because he has offered a lesser quantity.
We cannot hold who is fair, who is unfair. In senior counsel, the appellant in the present intra-court appeal has put to challenge an order dated 21/9/2023, passed by a learned single judge of this court in WPC number 27077 of 2023. Stop. The main ground which has been taken to question the legality of the said order is that the appellant was granted temporary permit to run his vehicle on the route in question. But in his absence, but despite the fact that he was not impleaded as a party, though he was a necessary party, the writ petition has been disposed of with a direction to the Chairman, State Transport Authority, Orissa, to revisit the question of grant of permit on the route in question. Stop. Next. After some argument, and senior counsel seeks permission to withdraw this writ application with a liberty to seek review/recall of the said order passed by the learned single judge, invoking appropriate provision of law. Stop. This writ appeal stands disposed of as withdrawn with the liberty as sought.
I was only praying for a protection for a limited period, because what has happened, your lordship will see paragraph 10 of the writ appeal. Post facto the disposal of the writ petition, they served a notice, and because of the protection granted by this noble court, I have been now granted with also permit because December it expired. I am conscious, my lord. Functions officio concept, I am conscious of that, my lord.
You're not conscious. You're not conscious. You know better than.
But that will be the issue.
Very difficult. Very difficult. Once we are disposing of, we should not file an application. It goes without saying that the appellant shall be at liberty to seek interim order, interim protection before interim protection, if so required, while seeking a review/recall of the order.
I'm grateful, ma'am.
Item 26.
Lordship, item number 26, I'm for the appellant. Seek for an adjournment, Lordship.
Hey, when?
Lordship, 1 week time.
Because requested 1 week.
Item 27.
Obliged, Lordship.
7 minutes, no counter has been filed, my lord.
Is it counter file?
Sir. No counter has been filed. Submit a copy to them.
A copy of the counter affidavit filed in this case on behalf of the opposite parties is being served in the court upon learned counsel for the petitioner. Are you giving?
Yes, I'm just giving.
Stop. Unless this case on 4 weeks, so as to enable learned counsel for the petitioner to consider the counter affidavit and file the rejoinder if so advised.
Item 28.
Your Lordship I'm though for the opposite party municipality. Yesterday, Your Lordship had heard that. I raised the point of maintainability of his locus standi before Your Lordship. Your Lordship had heard it practically yesterday.
Yes.
My lord, regarding the locus standi, my lord, the Jilla Nagari Committee is a registered entity, my lord. It is social organization looking after the betterment of the residents of the Devgarh municipality. So they have the locus standi to file such a petition, my lord, because the public is getting affected. Construction of the vending zone in front of the town hall, my lord, will lead to traffic congestion and many important functions which are being carried out there. They cannot be carried out, my lord.
There is no interim order.
Yes.
There is an interim order, my lord.
The entire construction has been stayed, my lord.
Order dated 21/7/2023, my lord. Several grounds have been raised in such an order.
My lord, my humble submission before Your Lordship is, Your Lordship may see paragraph 4.1 of the writ petition. And in my counter affidavit, I have stated in para 3 as well as para 13.
Is it a registered society?
My lord, kindly have a look at Annexure 6 of my writ petition, page number 25.
Mr. Sattar.
My lord.
My lord wants to query whether it is a registered society.
My lord, I am coming to it, my lord. It is there in the register number is there, my lord. Annexure 6, page number 25. Jilla Nagari Committee, a non-government welfare unit of Devgarh district, register number 17 of 2017. Annexure 6, page number 25 of my writ petition.
In the top left hand corner.
My lord.
He was
the registered society under Societies Registration Act.
My lord.
Where is the interim order?
Interim order dated 21/7/2023, my lord. First order. Order 1.
With Your Lordship's permission.
So affidavit has been filed by the Superintendent of Police.
My lord.
Superintendent of Police has filed.
Yes, my lord. Yes, we have.
What is your stand?
That is Rajiv Lochan Naik. I'm sorry.
OP number 5.
OP number 5.
Page 78.
Yes. Yes. They replied to be there. It is humbly submitted that no knowledge regarding the government. There was an inquiry conducted by the SDPO and the OP number 5 intimated about traffic congestion near the town hall as in the letter number to the collector district. The letter number so and so, letter number so and so, the representation are admitted by the opposite party number 5 in the report. Opposite party number 2, which was issued by letter number so and so and so and so, had mentioned that during course of inquiry, the SDPO of Devgarh visited the spot and noticed that some laborers were engaged for renovation of the drain as well as removing the plaster of the hostel situated in front of the town. Being asked to them, they have been said to renovate the drain as well as remove the plaster of the hostel for its renovation. Before further interrogation, they disclosed that after completion of the renovation of the drain, it will be covered with slabs and food zone will be created between the drain and the existing road. It is to mention here that the existing road has been marked with a median of parking of two-wheelers from the Shauchalaya to the market. It is busy place surrounded by Shauchalaya, town hall, backside of RBD High School, and more important is the main market. A number of functions is being organized in the town hall and the vehicles are parked in orderly manner in the median of the road, which has been marked as well as the remaining space of the road. If any proposal for creating food zone is there, then it will be cover the space of the existing road, and after the median is filled with vehicles, then hardly any space will be left for movement of other vehicles, thereby creating chaos on the road during the organization of any event.
Lordship, in the counter by OP number 5, my lord, para number 7, last para, they have admitted the facts as fact, my lord. May I, my lord? Further, it is humbly submitted that OP number 5 made a preliminary inquiry at the beginning of the objection of the public and had no knowledge about the construction of the project under the approval of the head of district administration and accordingly submitted his report. From the study of the order of OP number 2, it is clear that the project is not against the interest of the public. In the preliminary report, they have accepted the fact that it is against the interest of the public due to the congestion of the road, my lord.
But he says that he was not aware of the fact, and now a space has
On
been
the preliminary
provided.
report, they have admitted the fact that it is affecting the public.
He was not aware, and then sufficient space has been provided.
My lord, kindly have a glance at my IA.
And in such matters, the public interest does not mean that what you think is in the public interest. Finally, they have to take a decision.
My lord, kindly have a glance at my IA. 1452/23, my lord, that have annexed some photographs, my lord, in the page note 5 and 6, my lord.
We cannot substitute our opinion in place of the opinion of these officials.
My lord, only 2 photographs, my lord.
What photograph?
Of the vending zone, my lord.
Why should we see?
It's covering half of the road, my lord, the vending zone.
We should not get prejudice. So many places because of encroachment or something, free flow of traffic is affected.
The last picture, my lord, the vending roof of the vending zone is covering the half of the road, my lord.
Who should take a decision on this? We will not.
And collector is the authority to take the decision. Collector.
Collector has taken the decision which is under challenge for your lordship. That is at annexure 14, page 52. And collector has given a finding, your lordship, if your lordship will see that, heard the appellant. It was remanded once by this honorable court to consider their grievances.
Justice.
Has come up before your lordship was the ex-chairman of the municipality.
That we remember.
Yes. And once he having been unsuccessful in the election, he has been fighting for filing every cases just to stop
all right, that he can do. Now he is free, he can take up public cases of public interest.
But this collector has made an inquiry and given an order under annexure 14. So it was once remanded by your lordship.
Maybe. From this court's order dated 21/7/2023 and the pleadings on record, it can be easily discerned that
the dispute in the present writ application in the nature of public interest litigation relates to construction of vending zone by
Municipality.
Municipal. Devgarh municipality.
Devgarh municipality.
Devgarh municipality.
by Devgarh municipality. In which area?
Well, this is
Near town hall.
near town hall.
Devgarh? Near Devgarh town hall.
Town hall.
First off, the petitioner claims to be a society registered under the Society Registration Act, and the present writ application has been filed through secretary.
My lord. President.
President.
President of
The
the
president of the said society, Sunil Kumar Kapardar,
Sushil Kumar Kapil.
Sushil Kumar.
Sushil Kumar Kapardar, who himself, Kapardar, an ex-Mukhia, an ex, what is he?
Chairman.
Ex-chairman of Devgarh municipality.
Municipality.
Devgarh municipality. So stop. It transpired that his grievance is based on a report submitted by the subdivisional police officer Devgarh to the effect that construction of vending zone at the said place shall adversely affect free flow of traffic. First off, it further appears that earlier the matter was remanded back by this court.
Yes, ma'am. In WPC number 29148 of 22.
By this court to the collector, Devgarh, to take a decision. First off, a decision has been taken take a decision in this regard. A decision has been taken by the collector. Where is that?
Annexure 14, page 52, my lord.
By the collector on 4/5/2023. Following is the operative part of the said order. Page 52, having regard to stop. It is evident from the order of the collector that according to him, the construction of vending zone is not against the interest of general public, which has been taken up by the executive officer Devgarh municipality, observing all formalities. Stop. The said decision of the collector dated 4/5/2023 has been put to challenge in the present writ petition. Stop. There is an interim order of stay passed by this court on 21/7/2023, because of which the construction of vending zone has been stopped. So stop. From the submissions advanced on behalf of the petitioner and Devgarh municipality, it appears that whereas it is a specific stand of the municipality that construction of vending zone is in public interest, public interest, the petitioner asserts that such construction would adversely affect free flow of traffic. Oh, stop. Next. Exercising power of judicial review under Article 226 of the Constitution of India, in the facts and circumstances of the case, based on affidavits contradicting stand of the affidavits of the parties contradicting stands of each other, this court does not have any wherewithal or the judicially determinable parameters to record as to what is best in the public interest. So stop. Next. In the aforesaid background, we deem it proper to request the divisional commissioner. Oh, divisional commissioner or division?
Revenue Divisional Commissioner.
Revenue Divisional Commissioner.
Northern Division.
Northern Division. Cuttack. Sambalpur. To personally look into the matter and submit a report to this court for this court to reach a definite conclusion. So stop. We make it clear. That the divisional commissioner, revenue divisional commissioner, shall be submitting his report as an officer of the court and shall join the court proceedings online on the next date. That is, next date. So stop. Place this matter on 4 weeks. To assist, join online to assist this court. We make it clear that the said report shall not be required to be filed on affidavit.
Shall not.
Not be required to be filed on affidavit.
We'll just
give it.
He will join online. To assist this court, he will.
Lordship fix a date and 2 p.m.
Date we have given, 2 p.m.
16th April.
16th
of April.
Grateful.
Yes, Mr. Park. You are waiting for your Mr. Palit. We had assured you that we will hear you. Who is for the other side?
Statement.
Has he given consent?
My friend for the state.
Has he given consent? Who is for the other side?
My lord, I am appearing. In fact, on last occasion, there was a direction to take instruction whether he can be granted temporary recognition. That instruction is not with me. Your lordship may call this matter on 28th. By that date, I will take that instruction.
28th.
28th.
Yes, we can take it. 28th. Item 31. Yes.
Grateful.
Item 29.
May I please your lordship? My lord, this is a PIL under the Odisha Excise Act, my lord. My lord, here, lordship, first of all, before going to the fact of the case, I would like to draw lordship's attention to show that the policy, already your lordship has gone through that policy, excise policy meant for the excise year 23-24, that is at Annexure 11, page 40.
What do you want? Let us understand.
40,
Who are you and what do you want?
I am one of the public of that area where the petition OP number 5's beer parlor has made functional since long.
Where?
Beer parlor. Beer, that is beer on shop. Only he is licensed to sell beer. He filed an application in the excise year 22-23 for on-shop license. So lordship knows, for new license, for renewal, for shifting, everything public notice is mandatory. The intention of the public notice is to invite objection from the inhabitant of that locality. So the present petitioner is the inhabitant of that locality. He filed an objection that was not considered. I approached the lordship, the lordship directed to consider. It was considered. Thereafter, the government, after lapse of that excise year, though there is a embargo for grant of on-shop license, already your lordship has held. They have granted the license. That has been also interim order. By virtue of interim order, he has not yet able to get the license. So only I would like to show that that particular clause, my lord has already passed order. That Locking cross case.
Who is respondent number 5?
Myself. That beer for license.
Which order?
Your lordship, sir.
All right.
Your lordship was already held. There will be no on-shop application or license for the excise year 23.
We have not held. We have just said that this is the policy.
And also yesterday there were 60 cases. I had
You are other side.
that policy, and the lordship has kept it reserved for order. What happened, lordship, for moment, Annexure 1 at page 12.
But anyway, this is coming to an end.
Yes. And that Annexure 10, my lord, what happened? The government has made a policy. Now they have violated their own policy.
Next time they may not violate.
My lord.
After this license is up to 31st of March.
No, license has not been granted. Only that lordship see the impugned order at 10, Annexure 10, page 39. Even if after the cut-off date, my lord, after the extended period, lordship knows, 3 months they are granted. After they have given on 5th July 2023, in absence of any application, in absence of inquiry as required under section 20 and 31, nothing, my lord. Blindly they have granted. So you may see the section 20, what says. Page 29, my lord. Act. Lordship got it. Section 20. Grant of exclusive privilege of manufacture and sale of foreign liquor, Indian made foreign liquor and country liquor,
Mr.
or
Das.
the
Yes.
or other intoxicants, etc. First, the state government may grant any person on such conditions and for such period as it may think fit the exclusive privilege. Clause 1, my lord, Roman 1, the manufacturing or of supplying by wholesale or both, or by selling by wholesale or by retail, or manufacturing or by of supplying by wholesale or of both and selling by retail. Any liquor or other intoxicant within any specified local area, provided that public notice shall be given of intention grant of any such exclusive privilege under this preceding of subsection, that any person objection made by any person.
We have not been able to. He has been granted license.
He is, since long he is a beer parlor, my lord. Only he is authorized to sell beer. Then he
can violate. See, do you know section 379 of the IPC? What is that?
Theft.
Yes. So whether someone can commit theft or not. Then you can do that. All right. Despite the fact that there is a penal provision, it is being committed every day.
My lord.
So if he is doing something, he
No, he's not doing, my lord. He intended to convert it to on-off.
All right.
Then there is a bar.
There is a bar, then action can be taken against him.
Then that's why, my lord, I have approached lordship that
Is this your case that he is the only person in the state of Odisha
not
doing it?
state government has not granted any beer parlor to on-shop license. This is the first time that Annexure 10
All right.
have shown. So if lordship has already held that
there is penal provision, penalty, he can be proceeded against.
the state government has Annexure 10 page 39. How, my lord, there is a bar for grant of on-shop license for the excise year 23-24.
Mr. Whether he has been granted license or not.
Not yet. Because
then what is he doing?
Only selling beer?
He is committing crime. If he has not been granted license and he is doing something in contravention of the excise policy or excise law, then he can be punished.
No, he has not done it. He has only selling the beer. On-shop means, my lord, he can sell beer, he can sell rum, he can sell scotch, he can sell gin, everything.
So what do you want?
So he should not be, because there is a policy not to grant any license for 23-24.
So this is what we are asking again, that whether he has been granted license.
Not yet granted. That is an order by the government only. Annexure 10. He's trying to get the license.
Anticipatory order.
Yes, my
No,
lord.
not anticipatory.
Anticipatory. Anticipatory bail.
He has been given a license to sell beer only within his premises. That shop is running since last 5 years. He made an application to convert that beer parlor to on shop for sale of IMFL, that is Indian made foreign liquor. By Annexure 10, government directed the collector
Recommended.
issue license by way of conversion from selling beer to selling Indian made foreign liquor. Now, by virtue of your lordship's order, interim order, he is not given the license to sell IMFL, only he has been licensed to sell beer.
That's what I'm doing.
Don't press.
So your lordship may pass, your lordship already passed that whole that clause is bad in law. So Annexure 10 has to go, my lord.
No. The council appearing on behalf of the petitioner states that the respondent number 5 is attempting to obtain license for
on-shop by way of conversion from beer.
IMFL on-shop.
IMFL
IMFL on-shop by converting
from beer
parlor. Existing beer parlor.
By converting trying conversion of his beer parlor
Existing beer parlor.
into
IMFL on shop, which is not permissible in view of the excise policy.
23-24.
Odisha excise policy 2024.
24, that clause 24,
2023-24.
that clause, my lord, your lordship had mentioned
24,
421.
which has been upheld by
this
court. Stop. Next.
4.2.3. Roman 1.
Roman 1.
Bracket Roman 1.
Roman 1.
4.2.3 bracket Roman 1 of the excise policy. It is an admitted fact that respondent number 5 has not been granted such license. Top learned AGA representing the state of Orissa has submitted that in view of this court's decision, the decision in case of so and so.
Interim order. Because of the interim order passed in this case, license has not been granted to me.
No. We are recording his submission.
That is Lakshmi.
No.
All right.
Well, that is Lakshmi Priya Kara versus state of Orissa.
That's not the case.
No, I support the stand of the government because government has been pleased to direct for issuance of license in favor of the petitioner. OP number 5, Annexure 10. So often I cannot say that it's bad in law, my lord.
Your lordship has held that that is bad.
No, not yet.
Policy stands good.
Not yet.
Representing the state has submitted that so far license has not been issued.
License, yes. License has not been issued by the collector.
Been issued by the licensing authority. Stop. Learned counsel appearing on behalf of respondent number 5 has, on the other hand, submitted that the license has not been granted because of an interim order passed in this case. Stop. Next. Be that as it may, we are of the view that this application is premature and deserves to be dismissed on the said ground alone.
In view of the lordship's
Item number 30.
My lord, what happened? Because few days are late, my lord.
May I please, your lords?
Lord, in this case, the petitioners, the tribals of Sundargarh district, the entire district is scheduled area, my lord. They came up against the illegal conversions of the Gochar land of Adivasi people into Awadh Jagya Anavadi. And then Kisampati and the Tahsildar Lathikata handing it over to the Chief General Manager IDCO, Bhubaneswar, by issuing a ROR in clear violation of Article 244(1) and the 5th schedule of the Indian Constitution, which is relevant is Article 5(5), million.
So whether counter affidavit has been filed?
Yes, Lord.
The counter means, my lord, your lordship has directed them to produce the lease case. They have produced it and filed it with the affidavit. That is that taking it as a counter. And I have also made my objection. My lord, so before going to the details, my lord, let us have a glance at Article 244(1) as well as the 5th schedule, my lord. 244(1) clearly says the scheduled and tribal areas.
241?
244.
244.
Lords, from the beginning, may I say one thing, Lords? Lords, may kindly come to the prayer of the writ petition, Lords. At page 9, my Lords. Page 9. Under the circumstances, the petitioner most respectfully pray that the Honorable Court may graciously be pleased issue a writ of nature of writ of certiorari quashing the impugned order under Annexure 6, treating the same as illegal. And what is Annexure 6? It's a notice to the public to file objection for conversion where the government is not contemplating conversion of the land for alienation or creation of the land bank. And there is a notice without much.
I am clarifying everything, Lord. I am clarifying everything what my understanding is saying. First, let us come to 244(1) and the 5th schedule. Here they say administration of scheduled area and in tribal area. Administration of scheduled areas and tribal areas.
Translated copy of this, it's not filed.
Not filed.
File it.
I am coming.
File it, otherwise you will be arguing before a single judge.
That is the only document which you want to question.
Yes.
Then counsel for the petitioner is permitted to file an English translation of Annexure 7 to the 7. Annexure 6 and 7 to the writ application. Also, for the said purpose, this matter on 1 week? Huh? 5, 6, 7. 1 week, 2 weeks.
Will file the amendments?
No, just file it.
English works on
okay.
Otherwise, I will not be able to.
Okay.